The next item is the draft residential tenancy Jersey Amendment Law lodged by the Minister for Housing. The main respondent is the chair of the Environment, Housing and Infrastructure Scrutiny Panel. Before the summer recess, the Assembly agreed in accordance with Standing Order 79 to request the Environment, Housing and Infrastructure Panel to consider whether it wishes to have the draft law referred to it. Deputy Joan, I must ask you, do you wish to have the draft law referred to your panel?
No, sir.
Thank you. Minister, we now begin the debate again. I ask the greffier to read the citation and the Minister will then propose the principles.
Draft Residential Tenancy Jersey Amendment Law 2000, a law to amend the Residential Tenancy Jersey Law 2011, including to improve tenants' rights under residential tenancies, the states, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Thank you, sir. In the run-up to this debate, I wasn't entirely sure how to approach this speech, given that it's for the exact same purpose as the one that I gave at the last sitting. So I did genuinely give serious consideration to simply standing up today and saying I refer members to my previous speech and then sitting back down again. But members will be very relieved to learn that that won't be what I'll be doing. There is still much to be said, and events in the intervening time have given us plenty of material to work with. In particular, the report from the Environment, Housing and Infrastructure Scrutiny Panel, which I'll reference later in my speech, which has been extremely helpful, and I thank them for their work. But since the last debate, the basic facts have not changed. Jersey has a residential tenancy law that provides an inadequate framework for governing how residential tenancies operate in Jersey, which falls far below good practice and leaves ordinary Jersey people just trying to live their lives vulnerable to practices that nobody can muster up any justification for. And this happens not because of a lack of education or a failing to enforce the rules that already exist, but because those rules are flawed. Those flawed rules allow injustice to prevail against fairness and decency. And this is known far and wide among islanders, many of whom consider it to be one element of our multifaceted housing crisis that has left so many lacking confidence that they can enjoy a prosperous future in Jersey. And I re-invite members to consider the cases that I mentioned in the previous debate, such as the woman in her 60s who's living with cancer in a home which is developing mould, where the landlord has told her that she will issue an Article 6 notice to her if she complains any more about it. And there is nothing this woman can do about it. The young woman who embarked on a tenancy with her boyfriend, signed a renewal because it was all going well, but after it fell apart a month into that renewal, found that the only way she could get out of her obligation to pay 11 months' worth of rent on a single income was to pay an extortionate fee that she could barely afford. And there was nothing she could do about it. Also, the single mother who needed to move home for the well-being of her young daughter found a tenant to replace her and did all the work to make it happen and put a deposit down for a new rental home, only to be stung at the last minute with a completely made-up fee that she just had to pay because she had no rights. And there was nothing she could do about it. All of those are real cases that I have encountered, but was powerless to help with because the law was not on their side. The framework of fixed-term tenancies that don't allow flexibility for when life-changing circumstances occur, combined with insecure periodic tenancies that can be ended on the whim of a landlord for the most devious and morally unacceptable reasons, represents the worst of both worlds. It's out of step with how many other places manage their systems, including, soon to add to that list, England and Wales, where the Renters' Rights Bill just yesterday left the House of Lords on its unstoppable journey to becoming law soon enough there. Our complete lack of any provisions for how rent increases can be dealt with creates a race to the top disconnected from supply and demand, as rental contracts have no limitations on what increases can be extorted for a renewal or continuation. The tenant is helpless to negotiate or bargain because they can simply be given an Article 6 notice or have a renewal refused if they have the nerve to try to negotiate. But in painting that rather bleak picture, many will reasonably ask the question, but what about the landlord-tenant relationships where everything's going well and there aren't any problems? Well, sir, the good news is that we can strengthen our framework in such a way that prohibits the worst behaviour in the market without unduly restricting those who are getting on fine or imposing requirements that to the majority will cause more hassle than they're worth. It is a fact that the framework proposed in this draft amendment law is a passive one. It does not create reams of new bureaucracy to produce or hardline requirements to surrender yourself to some state institution. It works on the premise that in the first instance, everyone will just manage privately between themselves where common sense and mutual agreement will be allowed to prevail. It's only when things go wrong that changes will truly be felt by those who are responsible for wrongdoing, and that counts for both landlord and tenant. And from any member who wishes to dispute this in this debate, I don't want to hear platitudes or lines fed to them by lobbyists. I want to hear specifics. If, as happened in the last debate, a member wishes to criticise the draft law, claiming that it creates, for example, red tape, I want them to tell us what red tape and tell us specifically and clearly exactly what is that red tape proposed in this law. If a member wants to claim that the law creates more state oversight of private contractual relations, they should tell us exactly what state involvement is proposed by this law. Tell us the article that contains it. And if they want to claim that there are measures in the proposed law that disrupt residential tenancies in a way that damages those relationships that are going perfectly fine now, they should substantiate that and explain clearly how and why the provisions in this law do that. Not just vibe, but substance is what they should do when making those claims. And so I invite that challenge deliberately, because when it comes to it, I'm confident that the critics of this law will be unable to meet that challenge. Because the fact of the matter is that this draft amendment law proposes no new forms, no new fees, and no new permissions. This regime is exclusively to the benefit of good landlords and good tenants, and exclusively to the disbenefit of bad landlords and bad tenants. The framework I'm proposing for tenancy types will deliver greater security of tenure for tenants, whilst providing enhanced pathways for landlords to regain possession of their properties when they need to. The framework I'm proposing for rent stabilisation is about the most moderate kind that you could possibly imagine, where landlords will be free to propose whatever rent increases they feel are necessary. It's just that the tenant will have the right to appeal to an independent tribunal if it is proposed to be inflationary and unjustifiable. And this service, in all likelihood, will probably not be used that much because the mere fact it exists will help influence behaviour and ensure those involved in imposing rent increases ask themselves the question, is this necessary and justifiable? So, whilst the draft amendment law itself, in my view, represents a cool balance that manages to provide a system that grants protections without doing so at the expense of the convenience of others, I acknowledge that not everybody was convinced of that last time round. I've listened over the summer to those who still had misgivings about it, and that's why I'm accepting two amendments that I hope will allay the concerns that some had. I'm accepting the amendment from Deputy Renouf, who's proposing that the limit on rent increases above which a tenant can become eligible to appeal it to the rent tribunal should purely be set at RPI rather than the mechanism that I had originally proposed of either RPI or 5%, whichever was lower. Whilst the combination of RPI and 5% came about from looking at practice that already exists in the market, I feel comfortable that the prospect of RPI going above 5% anytime soon is slim enough that the RPI level on its own represents such a substantial step forward for protections for tenants that moderating my position on this as an olive branch to others is something that I'm happy to offer. This is pragmatism over purity. The second is that from the scrutiny panel, who've proposed introducing a new no reasons ground for issuing notice to a tenant. I might otherwise have been inclined against such a proposal in case it opened up a loophole that could be used to commit revenge evictions against tenants. But the notice period the panel have proposed at 12 months is so substantial that I just cannot foresee a situation where a landlord wanting to be harsh and unreasonable would have enough patience to see that through. But meanwhile, it could be used by a landlord who was planning for the long term but felt that their circumstances weren't necessarily covered by the other grounds that are provided for in the proposed new Article 6. And so giving them that option would not be unreasonable. So I thank both Deputy Reniff and the scrutiny panel for proposing those amendments. So moving more broadly onto the scrutiny panel's report, I thank them for their work and the constructive manner in which they've engaged in it. I paid close attention to all of the evidence that they received as they conducted their review, and I changed my position on some things as a result of it. I've proposed an amendment to the grounds for notice on serious and repeated nuisance, which was in direct response to their work on this, and I'm accepting several of the amendments they're proposing, which I think will enhance the law. Their report makes several points that stand out to me. In particular, many findings that they offer on the perspective of tenants, a perspective which has all too often not been adequately platformed in these debates. They found that many of the housing insecurities that I've attempted to highlight were fed back to them by tenants who either experienced them directly or feared that they would, and the impact that would have on their behaviour. The chair, in her forewords to the report, says that from the evidence they received, it's clear that there is real merit in improving the current law, and I completely agree with her. They also heard evidence from several key organisations at the coalface helping islanders with housing insecurity, such as Caritas, Shelter Trust and Sanctuary Trust, who are all in wholehearted support of this draft law. I have to admit, though, my favourite part of their report is the line that says there is significant misinformation and confusion around the law and the proposed amendments, making it harder for islanders to engage with the real issues. You can say that again. There is no doubt for me that the most depressing part of this whole episode has been the misinformation, proliferated by some out of naivety and others out of something worse, that has made it harder to have a clear and constructive debate on this draft law. In my speech during the last state sitting, I included a myth-busting section where I went through that misinformation and tried to set the record straight. I won't repeat all of that, sir, except to reiterate what I said earlier, that the draft law proposes no new forms, no new fees, and no new permissions, and anyone who suggests otherwise is not being accurate. Instead, I want to focus purely on the freshest misinformation, sir. A few days ago, States members received a communication from one lobby group. And of course, sir, I defend every member of our society's right to organise and engage in free speech. But as a source of some misinformation that's been spread in this debate, I make no apologies for tackling those comments head on, but I'll focus purely on three statements. In fact, you can't even get through the first paragraph of their circular to us before finding misinformation. In this, they described this legislation as rushed. Sir, the absolute temerity. This project has been in the works for over 5 years. It really is absurd to claim that it has been rushed. Far more attention has been given to this project than so many other pieces of legislation affecting island life and our economy. Later on, sir, they refer to new periodic tenancies making it more difficult to obtain vacant possession. This is also false. The process for obtaining vacant possession will remain the same as it is now. The landlord issues notice. They expect that notice to be complied with. If it is, no problem. If it isn't, they seek an eviction order through the Petty Debts Court. That remains the same under the old law and the new law. The changes are in regards to the grounds for notice being issued, which in many instances will actually make it easier for landlords to regain possession of their properties. Instead, sir, of what we have now in Article 6 of the Residential Tenancy Law, which is a blanket 3-month notice period, there will be various lengths of notice depending on the reason for issuing it. And some of those reasons, such as the tenant causing a serious nuisance, will come with a much shorter notice period, so the landlord can get to the Petty Debts Court quicker if it's urgent and necessary. And for the first time ever, the Petty Debts Court will lose their discretion on a stay of eviction in some circumstances, as some grounds for eviction will become mandatory. That is actually something that came about as a direct result of a suggestion from the Jersey Landlords Association in my consultations with them. And I offer that to make sure that for when those genuine circumstances arise and where a tenant is absolutely in the wrong and potentially causing harm and risk to that landlord's asset, that the law is not on their side, but instead on the side of the landlord who is in the right. And this law makes advances in that direction, which in some quarters does not get the credit it deserves for that. The only landlords who will find it more difficult to obtain vacant possession of their property will be those who have no legitimate grounds for seeking to do so, but are acting in revenge or retaliation for a tenant seeking to have their legal rights upheld. If they attempt to do so, the Petty Debts Court will now, for the first time, have the power to overturn that notice on the basis of it not being issued lawfully. I contend that those who would seek to force a person or family out of their home in revenge or retaliation for simply seeking to have their legal rights upheld are not the people we should be standing up for. Lastly, sir, under unintended consequences, they refer to the consequences of making an error, such as issuing an incorrect notice to quit, can be severe, a £10,000 fine. Sir, this is false. Nobody, I repeat, nobody will be faced with a £10,000 fine for making an honest mistake. The offence that they are referring to is giving false or misleading reasons to end a tenancy. In other words, lying. It means knowingly or recklessly stating a false reason for issuing notice. For example, wanting to get rid of a tenant for complaining about mould, so just issuing notice and claiming that you intend to sell the property, but then letting that property out right away as soon as the tenant has gone. It is not for those who honestly and genuinely thought that they were doing things correctly or had a change of circumstance arise after the notice was issued that meant they had to change their plans. In neither of those kinds of circumstances would they be covered by this or meet any public interest test for a prosecution. But sir, it's no wonder that many of their members would report that they are considering selling their properties after being told that they could be made criminals for making an honest mistake. But it's not true, and it's unfair to mislead honest people in that way. And I'm confident that once they know the truth about how this law would affect them, many will end up asking the question, what was all the fuss about? In their email to their own members, the Jersey Landlords Association referred to the election coming up next year. I have to say, I think that's a misjudgment on their part. Of course, sir, I defend their right to freedom of speech and to make whatever points they wish to make, but I believe in making that point, they're unaware of how their interventions in the political realm are viewed by the majority of the public. They are perceived, when making these points, as representing vested interests diametrically against the macro interests of the people of Jersey as a whole. They've frequently opposed common sense and proportionate proposals to improve regulation in the rental market, such as the Deposit Protection Scheme and the Renter Dwellings Licensing Scheme. They did this initially with some success, but when they were eventually defeated, they had all of their doomsday predictions proven wrong. Those states members who were most closely associated with their agenda in the last term of office paid the heaviest price for it at the last election. And I think the reason for this is obvious. People in Jersey want to live good lives and want the people they care about to live good lives. And they don't like seeing other people being treated unfairly. And at the end of the day, an agenda that says we should preserve the right of bad landlords to throw tenants out of their homes in revenge for the tenant making reasonable requests or seeking to have their legal rights upheld, and preserve the right to ramp up rents until the pips squeak when there's no economic justification for it, is just not something that people like, especially when the mechanism to correct all of that does not involve overbearing impositions on the good landlords. But sir, it's not just renters themselves who feel that way. Affluent people in our society, middle-aged people in our society, want to see their children prosper in Jersey, and they don't like much of this argument either. Many of these are people who, having bought their own family-sized home at a relatively young point of their adulthood, look on at their children's prospects, where they will either have to live at home with their parents until they're in their 30s to be able to afford to buy a bog-standard one-bedroom flat, or leave in their 20s and never be able to afford their own mortgage because they're spending over half of their income paying somebody else's mortgage for them. They recognise that this prospect is making their children consider a life elsewhere. In the last debate, sir, I spoke of my experience meeting students at JCG, where I asked them how many were planning to come back to Jersey after university, and not a single one of them said yes. The public, by and large, want action on this subject, and they resent the way that our politics has, in the past, been so beholden to minority vested interests. It's clearly featured as part of their thinking at the last election, and I have no doubt that it will do at the next one too. But sir, that needn't be something that worries us, because we have the opportunity to do the right thing. We have the opportunity to support a balanced and carefully considered piece of legislation that proposes a framework for renting that advances the rights of good landlords and good tenants whilst taking proportionate action to counter the bad landlords and bad tenants. And it's for those reasons, sir, that once again I commend the principles of the draft amendment law to the Assembly.
Thank you, Minister. Are the principles seconded? Yes. Can I remind members of Standing Order 106, before we go any further, the declaration of interests obligation which arises in relation to this matter? Hitherto, people have made declarations of those interests. Deputy Gorst. Deputy Jern.
Yes, sir. I rise as a tenant, a chair of a homeless charity that owns a number of properties, and a landlord.
Deputy Renouf.
Landlord.
Deputy Rose Binet.
Yes, I'm a landlord, sir.
Constable St Clement.
Sir, I'm both a landlord and a tenant.
Deputy Andrews.
I'm a tenant, sir.
Deputy Tom Binet.
Landlord, sir.
Deputy Howell.
I'm a landlord, sir, but for a family member who doesn't pay any rent.
Deputy Luce.
I'm a landlord, sir.
Deputy Wall.
A landlord, sir.
Constable of St One.
I'm a tenant, sir, and also parish have 39 rental units. I'm not sure whether they come under this law or not.
Everything. Constable St Mary.
Landlord, sir.
Deputy Moore,
I'm a landlord, sir.
Constable St Peter.
Landlord, sir, but only to family members who don't pay me any rent. And I'm also a landlord of a house in the UK.
Deputy Labby. Yes. Deputy Wilson.
I'm a tenant, sir.
Constable St Helier.
My wife is a landlord, sir.
Deputy Catherine Curtis.
A tenant with a long lease, sir.
Thank you. Deputy Kovac.
I'm tenant.
Deputy Alex Curtis.
I'm a majority shareholder in a company that is a landlord.
Deputy Balash.
Landlord.
Deputy Gardner.
My husband is a landlord.
Deputy Messick.
Tenants.
Thank you. Who wishes to speak next on the principles? Deputy Barbara Ward.
Thank you, sir. Before I present my speech, I would like to extend my thanks to the Chief Minister for his understanding and respect following my declaration not to support the principles laid down in this proposition. And it's the proposition that we got originally, not the amended versions that has been given out in the speech today. May I also thank the scrutiny panel for their rather extensive report of some 299 pages, which was most informative, but I have to say I found it far too long and at times confusing and disjointed. In particular to the referencing of experts' views, of which some of them there were about 18 recommendations, and had some difficulty in finding out the referencing where they fitted in. However, I read the report with an open mind and hope that it will provide me with comfort and assurance that my mind and views would have been persuaded to change. Sadly, sir, this has not been the case. I'm surprised and disappointed that little reference has been made to the Fiscal Policy Panel's Economic Outlook report, which was published in May this year, which very much tells a cautionary message of how we move forward, especially in areas of slow growth areas, which I'll talk to later, and have and will affect our economic situation in Jersey going forward in such global, volatile monetary climate. My main reasons for rejecting this proposition are an extended version of my previous speech, which I said in May earlier this year. On the 5% capping of rent increases, which at the 11th hour yesterday evening, this aspect I see has been, as a matter of compromise and a positive move, to be removed, which I welcome. However, when landlords make repairs and conduct ongoing maintenance, they need to be able to reflect these costs proportionately. So that's where it comes in about bureaucracy, that if you are putting it up, you do have to give the evidence. Repairs, maintenance and service costs are not capped and reflect market forces and supply. The only option for the landlord is to absorb these extra costs or apply more bureaucracy, produce the paperwork, that is, to evidence their increases. Private rental charges have not spiralled, but in fact have fallen by some 11.7%, as stated in the Fiscal Policy Panel's report, resulting in a loss since 22, £100 million to the economy. Yes, £100 million. I am unable to find the evidence to the contrary to justify a need to bring in rent stabilisation. 2, the changes in tenancy contracts. Renewable fixed-term contracts benefit both the landlord and the tenant, so they both know exactly where they stand. This approach has worked very well for many years. Many landlords can demonstrate that they do show some flexibility for a tenant who requests an earlier release from their lease in special circumstances. Many landlords are reasonable people and want the best for their tenants. It's in everyone's interest. It is alleged that changes are being proposed due to revenge evictions. The evidence is not there, sir. Out of some 21,000 public and private rental properties, only 7 evictions out of 21 applications to the Petty Debts Court were upheld in 2022. And from the recent Freedom of Information results show that the Viscount's Department handled just 2 private sector eviction cases in 2024, and there's been none recorded as of July this year. This is a very small number, with some relating to social housing providers. The evidence sought demonstrates there is little or no evidence to claim there are significant numbers of revenge evictions. Due to this clear lack of evidence, purports to using a sledgehammer, in my view, sir, a sledgehammer to crack a nut and go over the top. I do not condone bad landlords and/or bad tenants, which can be dealt with under the existing law and regulations. Therefore, I cannot see the need to make any changes at this time. Notice period, sir. Personally, I find it inequitable that notice periods are different. 3 months for landlords and 1 month for a tenant. Notice periods really should be balanced and equitable. As I previously stated, landlords are reasonable people and cognizant of people's special circumstances. They can do and vary notice periods, especially if tenant circumstances change, sometimes overnight through no fault of their own. For example, when a company ceases trading and closes, which has happened recently in the building sector. One particular firm is affecting 200 people in their firm. This is serious. I'm extremely concerned that these changes may have an impact on the island's economical stability. Rental attracted some 11.7% towards economical position in 2023. Out of the 45% homes that rentals provide, the private sector provides the large proportion of rentals, some 72%. Any downward trend by these proposed changes may affect the economic percentage, especially if private landlords leave the industry. The downturn will automatically place pressure on other areas of business and government to try and make up that shortfall. Please read, all members, please read the Fiscal Policy Panel's outcome report of May this year, which makes very sobering reading. And I quote from page 7 on the slowest growing sectors section. The real estate activities, rental, contracted by 11.5% to £100 million, reflecting a 13% decline in house prices since their peak in Q3 22. As high mortgage rates contributed to the decreased affordability and weaker market activity. Let's take some cognizance from that. There's a warning to us all in this volatile global financial situation. We have no idea what is around the corner. This is a serious risk factor, which we must heed. What I find interesting is that I previously in the Assembly agreed to hold back, and I'm sorry for saying this, £20 million from our state's grant into the Social Security Fund to help bolster businesses, increase employees' income towards the living wage, and to support improvements in Jersey's economical position. So why, sir, are we risking to counter this action? To me, it doesn't make sense without clear evidence to make these changes to our rental sector. We currently have the necessary laws and enforcement regulations. In my view, sir, may I encourage the Assembly to reject any moves which brings in a risk, changes and pressures on our economical position. We need to leave well alone in these uncertain global volatile times. Please may I note that moves taken to this proposition introduced in other jurisdictions has had adverse effects. One example is the experience in the Republic of Ireland, which provides a sobering scenario of unintended consequences. Rental controls there led to a collapse in the private rental investment market, and they have had difficulties to attract landlords back to the sector. Sir, members need to be cognizant of other jurisdictions' mistakes and experiences, as to ignore it may be costly to Jersey in more ways than one. I feel that this proposition may very well be intended, but in my view, I think it's a short-sighted gain which may result in long-term pain. These proposals may impact tenants due to lack of security on not having fixed-term leases with a definitive closing date. Fixed-term leases set out terms for both parties to follow and understand. These proposals incur more red tape, as I alluded to, that when you do increase, you have to produce the evidence. So these proposals red tape in the landlord through, example, updating lease agreements, who consider exiting the market by either selling or wanting their properties back for family members or themselves. If this happens, tenants will have to find other homes, especially 3-bedroom homes, which we all agree are in very short supply. This market reduction could incur tenant insecurity, higher rents, impact on inflation due to the demand for these types of accommodation. Properties are an owner's asset, whether it be owner-occupied or a rental property. More legislation is unnecessary at this time. The Minister considers there's a housing crisis which is not going to magically disappear overnight, as more family homes are needed. But these proposals could further increase the housing crisis by creating a short supply. Sir and members, overall, landlords do act reasonably by way of notice and management of their properties. These proposals, in my view, interferes and places barriers for the owner to retain their properties back due to the proposed hoops and increased bureaucracy being suggested. This cannot be right, sir. Sir and members, based on these aspects that I have just expressed, I cannot support this proposition, the principles, at this time. Please may I encourage members to reject this proposition also. Thank you very much. Thank you.
Thank you, Deputy. Deputy Catherine Curtis.
Thank you, sir. The last speaker spoke about the risk of bringing forward this proposition. We only have to look at the current situation due to the last few decades of inactivity to see the risk of not doing so. I made a speech on this matter back in July. My focus is on the bigger picture, the effects of unaffordable and insecure accommodation on Jersey generally. I made reference to the fact that this proposition had the potential for much greater impact than on rental housing only, and that our whole island's economy has been and is being affected by insecure and unaffordable accommodation. I received a good response to that speech, apart from one particular deputy who made reference to my speech with what I consider to be a straw man argument, stating that if all the problems I'd referenced could be solved by this proposition, he would 100% support it. Well, my speech stated that all the problems were connected to insecure and unaffordable accommodation, and that is a fact. It's a fact as demonstrated in almost every single survey and analysis covering these matters over the last few years. So just to summarise, the problems in our island connected to unaffordable and insecure private rentals are, firstly, young people leaving. The number of Jersey residents in their 20s and 30s keeps dropping. Many young people who leave say they cannot afford to live here. Secondly, lack of essential staff coming to the island. There are difficulties for all businesses in recruiting and retaining staff, and this affects the profitability of our economy and the standards that businesses can offer. Thirdly, difficulty in recruiting staff in the education sector, affecting our children's education, well-being and skills development. And it's not just staff in the education sector. Top professionals from the UK have been reluctant to join our emergency services due to high cost of living and housing. There is a struggle to recruit and retain social workers, affecting the experience of children in care and other vulnerable children, in fact, affecting their whole childhood. Also, there is a high cost to taxpayers due to unaffordable and insecure housing. Large amounts of taxpayers' money pay for the higher cost of agency staff and essential services. There are large amounts of taxpayers' money spent on the rental component for low-paid workers claiming income support. There are serious issues for the future due to young people feeling unable to afford to live here, the likelihood of an older population with insufficient younger people to support them, creating future well-being concerns and a potential huge gap in revenues. And after housing costs, which are some of the highest in the world, 29% of children live in households which are below the relative low income threshold, which is unacceptable. The high rental costs result in families with little or no disposable income. Statistics Jersey shows a high proportion of people living in private rentals are in rental stress, so less money spent in the local economy. And a really important point is about quality of life for people. Tens of thousands of people in our island are affected by issues such as not knowing whether they will have their home in 2 or 3 months' time as the lease end approaches, or that they may need to find another £200 or £300 per month like magic because they have no idea how far the rent might increase, or that they may need to move their children miles away from their schools. These are the sort of issues that we are here to address, and yet the State's Assembly has allowed for insecure and unaffordable housing to continue for decades, which leads me to the next point, which is low trust in the State's Assembly and government. Surveys show there is not a high opinion of States members. Many people say that we do not focus on the big issues like this one. And finally, low voter turnout. Because why vote when your needs are ignored? So everything I've just listed could be improved to a greater or lesser extent by making rentals more secure and more affordable. The proposition aims to do that. To not vote for this is to vote to leave things as they are. And where things are now is not good. Or to vote for certain sweeping amendments which will severely curtail the intent of this proposition and, in my opinion, make it purposeless. To vote against the proposition is, in my view, a dereliction of duty. It is a priority in this government's common strategic policy to, and I quote, to provide more affordable homes for islanders and more confidence for the rented sector. That's a government priority. The Jersey Landlords Association makes a case against this proposition. They're making a case for their members, and that's what they are supposed to do. They are a lobby group. States members are not here to support lobby groups. We listen to them, but we are here to do what's best for the island as a whole. There is overwhelming evidence that high cost and insecure housing is damaging our island in many different ways. I think this is one of the most important propositions to come before us, and I urge members to support the proposition.
Thank you, Deputy. Deputy Balash.
So I'm sorry to say that I think that the Minister's approach to this debate is regrettable. He has exacerbated divisions, publicly describing the debate as one hell of a fight, and shaped it as being as a kind of gladiatorial contest between vested interests and the forces of progress. I take exception to that. I have no vested interests. I want to protect the interests of landlords and tenants. I have declared an interest as a landlord, but I would add that during my life I have been a tenant on several occasions. I have been on both sides of the fence, and I am perfectly capable of applying an objective view to the Minister's proposals. The Minister objects to my description of his amendments as ideologically driven, but I am certainly not seeking to impugn his integrity. Quite the contrary, actually. I think it's a description of a conviction politician, which should be thought of as being a compliment. The Minister does have a conviction that tenants are badly treated by the law. That is the ideology that drives him. Actually, he is wrong. I don't think that there is very much wrong with the law. It's certainly not an inadequate framework, as he suggested. It may need tweaks, and it may not be effectively administered or explained, but that is another matter. I want to address briefly the views of some members that the principle should be adopted and the debate should move on to consider the detail. It will be obvious from the amendments that I have lodged that, in my view, the Minister's amendments are deeply flawed, and if we get to that stage, I shall explain why. But we should only adopt the principles if we think that the Minister is, broadly speaking, moving in the right direction. In my view, he is not. The general thrust of the Minister's proposals is that more regulation is the answer. He doesn't really understand what the problems are, but he has convinced himself that the solution is more controls. Landlords and tenants should be told what they can and cannot do. More regulatory bureaucracy should be established in the shape of a rent tribunal and rules governing what landlords can charge. That is not, in my view, the right direction. What would be the right direction? I think there are at least two things that the Minister could do which might lay the foundations for sensible amendments to the law. The first is to make greater efforts to ensure that landlords and tenants know what their obligations are, but more specifically, so that tenants know what their legal rights are. The 2011 law contains no express provision about explanatory guidance, but the Minister surely doesn't need a statutory prod to direct that some simple guidance be drawn up for the benefit of both landlords and tenants. The laws, regulations, and orders are there, of course, on the website, but they are not always easy to understand. Guidance in plain English would be of enormous benefit to everyone. I was struck by the Minister's story in his address to us a few moments ago about the constituent with cancer who was living in premises with mould, which the landlord refused to address. The Minister explained to her the minimum standards rules, but the constituent was unwilling to use her legal rights because she feared eviction. Guidance might have explained that landlords cannot evict tenants. Only the court can order an eviction. And it does not have to. The Minister is shaking his head, but that is the law. And if asked during eviction proceedings, the magistrate must consider a stay after taking into account numerous factors, including where the balance of hardship would fall and any other relevant factors. The fact that a landlord has failed to deal with mould must be a relevant factor. If the magistrate was told that eviction proceedings had followed because of a valid complaint about mould, I cannot believe that anything but a very long stay of execution would have been ordered. The tenant does have considerable protection. The law would not, as the Minister has asserted, have been on the side of the landlord. Simple guidance as to legal rights ought to go a very long way in helping people to resolve their differences. The second thing that the Minister could do is to assemble some data. There is virtually none underpinning these proposed amendments to the law. The Minister makes assertions, but the only apparent evidence is his inbox, which is obviously not available for inspection and critical analysis. He asserts, for example, that revenge evictions are perfectly legal in Jersey, a highly tendentious statement, but I will let that go. But where is the evidence? Where is the evidence that they take place? In his comments paper, the Minister admits that there is no data, but he states, and I quote, "The number of revenge evictions are unknown by design." But whose design? Who has deliberately obscured the number of revenge evictions? It's a nonsense. No one knows whether there are, in fact, any revenge evictions. The Minister has invented a problem in order to justify the solution of preventing landlords from obtaining possession of their property other than in specified circumstances. He could request information from the Petty Debts Court as to the number of occasions tenants face eviction because of an action taken by them, but he hasn't done so. Deputy Ward referred to this. It would be inconvenient to know, perhaps, that it rarely happens. Again, the Minister asserts that tenants, and I quote, "tenants can face excessive or unreasonable rent hikes with little or no warning." No evidence is offered to support that assertion. Given that landlords have an existing obligation under the 2011 law to provide tenants with an agreement specifying inter alia when the rent is to be reviewed and the basis of that revision, it seems surprising that excessive rent rises would be permitted by an agreement. Would a tenant really agree to a clause which allowed the landlord to impose rent increases as he thought fit? Rent increases have to be agreed. If a landlord proposes an excessive rent increase not covered by the agreement, the tenant can refuse it and should. Perhaps tenants don't know their rights, but then that comes back to the question of the absence of clear guidance. The important thing is that there is no data supporting the assertion that excessive rent increases are imposed. I don't say it never happens, but we should know the extent of the problem before we start to legislate. Deputy Barbara Ward spoke of the economic challenges and the economic effects of the amendments. Where is an economic impact assessment of this legislation? Scottish experience suggests that it will diminish the supply of rented accommodation and as a result cause an increase in rental levels. Is that a fair assessment? Why has an economic impact assessment not been commissioned by the Minister? Deputy Curtis is concerned about unaffordable rents. If the Minister's proposal might make matters worse, we need to know. The Minister's proposals do include a provision for requiring rent information from landlords, and if we get to the articles, I will support it. And if the principles fail and the Minister brings back a freestanding provision seeking such information, I will again support it. I hope that members will not support these principles. The Minister's approach is all wrong, and if we get to the articles, I fear that the complexities both of the Minister's proposals and all the amendments will mean that the likelihood of a satisfactory and sensible outcome is remote.
Sir.
Thank you, Deputy.
Sir,
Deputy
so
Mayor.
if I may just briefly, I wasn't here at the beginning of the debate, so I'd like to be recorded as being a landlord, sir.
Thank you very much. Deputy Taddeo.
I need to similarly state that my spouse is a landlord.
Thank you. Who wishes to speak next on the principles? If Deputy Chair.
Thank you, sir. The Assembly in July referred this draft amendment law to the Environment, Housing and Infrastructure Scrutiny Panel, as members were concerned that they needed more information to base their final decision on. Our final report was published at the end of August. It provides the evidence and analysis to hopefully help members to take an informed position. But let me be clear, this is not something that can be explained in a few pages. The issues are detailed, layered, and requires thoughtful examination. Regarding this principles vote, for the panel, our views have not changed since the July sitting in supporting the principles, but I will reiterate some key aspects for members. The amendment law marks a significant shift in the tenant-landlord dynamic. As a panel, we are united on our view that reform is necessary, and we fully support the Minister's overall objectives laid out in the principles of enhancing tenant security, improving transparency in the rental market, and introducing stronger mechanisms for dispute resolution. Housing is one of the most pressing and complex challenges facing Jersey today, with nearly half of households renting. A fair, balanced and effective rental sector is essential to the well-being of thousands of islanders. Landlords are an important part of meeting this need, and a fair and effective system benefits everyone. When we began our scrutiny of the draft amendment law, our panel asked a simple question: will these reforms actually deliver what the Minister has promised? Will they mean longer and more secure tenancies? Will they make responsibilities clearer for both landlords and tenants? And above all, will they strike a fair balance in our rental market? To answer these questions, we looked closely not just at the wording of the law, but at what it would mean in practice. We examined whether there could be unintended consequences, how workable the rules would be, and what lessons we could learn from how other jurisdictions have approached similar reforms. To help us, we engaged the Right Honourable Michael Tomlinson KC, a senior barrister and former Solicitor General for England and Wales and member of the UK Privy Council. His independent report contained 34 recommendations, many of which shaped our findings, but some did not. We also went out and listened. Over 300 islanders responded to our surveys. We took written submissions, held public hearings, and met with landlords, tenants, experts, advocacy groups, and sector bodies. The stories we heard revealed just how differently the rental market is experienced, depending on which side of the tenancy agreement you are on. Tenants told us about the stress of unpredictable rent hikes, notices to leave with little warning, and the feeling of being in a system that is stacked against them. Some even had no written lease agreements at all. For those already facing financial pressures or language barriers, the insecurity was overwhelming. Landlords, on the other hand, spoke about their fear of over-regulation, of red tape making it harder to provide homes, and of measures that might unintentionally drive them out of the rental market altogether. The panel found that the current system is confusing and often misunderstood, and doesn't provide the clarity, transparency, or fairness that either party needs. That panel also found that the draft amendment law has been misinterpreted by all stakeholders in different ways. There is widespread support for better data, clearer rules, and stronger enforcement, because good landlord-tenant relationships do exist, but they are far from universal. And when things go wrong, it is often those without power or knowledge who pay the price. We found that in some areas, the Minister's policy aims have not been fully delivered in the way the law has been drafted. And in other areas, the proposals may have gone too far, either by leaving too much to be decided later through ministerial orders or regulation, or by placing extra demands on departments that already have very limited resources. The introduction of rent stabilisation measures is a landmark shift. For tenants, it's about transparency and predictability, knowing you won't face a sudden steep increase that leaves you scrambling. For landlords, it's about whether the rules will still allow them to invest, maintain their properties, and stay in the market. Key stakeholders emphasised that an annual rent limit with a notice period and limiting the rise to RPI represented best current practices. That's best current practices. The panel received a substantial volume of evidence opposing the proposal rent increase limit of capping 5% or RPI, whichever is lower, and we've heard today from the Minister of his acceptance to amend this proposal. But without reliable data on rental prices, we cannot properly assess the economic impact, which is why the Minister's proposal for a new data scheme is vital. Making periodic tenancy standard is intended to end practices such as silent non-renewals that are known to happen under fixed-term contracts. The panel found a widespread perception of insecurity where tenants were afraid to raise concerns, fearing non-renewal through fixed term or abrupt notice, and to remind members that under the current 2011 law, under periodic tenancies, it is still a 3-month for landlord and 1 month for tenant notice period. That is what currently happens, with no reason. While tenants supported these aims of the changes to periodic tenancies, there is no clear evidence that periodic tenancies alone provide more security than fixed-term contracts. The Minister has proposed as well that an initial fixed-term contract must still be agreed for initial fixed-term contract may still be agreed for up to 3 years, alongside the introduction of statutory grounds for notice for periodic tenancies, which is designed to create the tenant security. That is the bit that we focus on, is that grounds for notice for periodic tenancies. However, even with this, the panel heard serious concerns about the shortest notice periods, especially the 7-day ground, and the need for clearer, accessible guidance to prevent misuse by landlords or unwittingly penalise landlords due to misinterpretation of the proposed law. So the panel has put a number of amendments to strengthen the new tenancy agreements. The creation of a rent tribunal is positive, but questions do still remain about resourcing, operations, and reliance on secondary legislation. The panel has made a number of amendments to ensure that the rent tribunal remains a passive mechanism. The introduction of a 2-tier penalty regime may deter bad practice, but proportionality and enforceability remains still a concern, and this will be touched on if we get to the readings of the articles and the amendments by the panel. An awareness of rights both under the current law and of the new law is low, and without well-resourced, accessible support for both landlords and tenants, the reforms risk failing in practice. So throughout our review, one thing has become clear. Tenants need greater security, transparency and fairness, but landlords also need confidence and clarity if they are to continue providing homes. So the law must work for both. Because if we get this wrong, the consequences may be serious. Fewer rental houses, higher insecurity, and a system that fails the very people it is meant to serve. So whilst we support the broad direction of travel, we have identified several areas where we believe the legislation could be improved to ensure that it is fair, workable and proportionate. And I hope that I will have a chance to present these improvements during the second reading of the debate through the articles. And on this, I would like to make one point absolutely clear. The Minister himself has welcomed the panel's work, describing our findings, recommendation and amendments as constructive. He even urged members to focus on them as the basis for the debate. It is therefore disappointing that the media, particularly the JP, misrepresented our work as part, and I quote, of the wrecking amendments. That is simply wrong. As I set out in my foreword to the report, the evidence shows that there is real merit in improving the current law. Islanders deserve a serious, open debate on the detail that affects their homes, rights and responsibilities. The panel has worked in good faith to develop evidence-led constructive proposals. To portray this as anything else undermines scrutiny's role, misleads the public and diminishes the hours of careful consensus building that we have undertaken. I would like to thank the Minister for not only accepting half of our amendments that members will discuss later, which partially paved the way for more comprehensive law, but for publishing his initial response, SR3 2025, to the EHI report today, which largely fully or partially accepts most of the panel's 66 findings and 18 recommendations. I'm also grateful to him for the time he and his officers gave during both the scrutiny process and in informal discussions. Members will have seen that the Minister has drawn on evidence gathered by scrutiny to strengthen his own amendments, a clear demonstration of the value of scrutiny in shaping good legislation. That said, the process could have been stronger had the Minister discussed those scrutiny-inspired amendments directly with us, allowing greater consensus and shared understanding of the aims behind them. I also want to thank my panel, sir, for their hard work and teamwork in reaching consensus on the report, not only on recommendations but on the amendments themselves. As members know, scrutiny members are under no obligation to support amendments put forward by their panel. I'm therefore particularly grateful that we are able to stand together on these principles and our proposed amendments, demonstrating that diversity of political opinion can still lead to genuine consensus. My thanks also go to the scrutiny officers and special advisor. Their professionalism, patience and expertise have been exemplary. Their detailed forensic analysis of a complex set of amendments has been vital, giving the panel confidence to navigate these issues with clarity and precision. Their contribution has been essential to the delivery of this report and to support the members today. And finally, I'd like to extend my sincere thanks to all islanders who submitted evidence or took part in our hearings. Their contributions have been invaluable in helping the panel gather a wide range of perspectives and ensure that our work is grounded in the experience and concerns of the community we serve. So for now, sir, I urge members to support the principles of the draft amendment law and to approach the detailed debate ahead with a spirit of collaboration and a shared commitment to thoughtful, balanced legislation that serves the best interests for both tenants and landlords. Thank you.
Thank you, Deputy. Deputy Dublé.
Thank you, sir. I'm delighted to follow the chair of the scrutiny panel, and I think she put it really well. And I wanted to reiterate that there's no war or battle here, and I think in this assembly, the majority of us are genuinely just trying to find the right compromise and listening to everybody involved. And I think with the help of the scrutiny review, that we've been able to do that and consider all of the issues really carefully. And hopefully, once we've debated all the amendments following this in principle debate, we will be able to get to something that is of the highest quality. And it is really important that we consider this issue and take it seriously. And the length of the documents, I think, has been mentioned by other speakers. And I think we've all felt that, haven't we? There has been a lot to read. And again, it's a really important issue. I think there's not a lot else that's more important than housing, is there, than the homes that we live in. Our health, perhaps, the relationships that we have with others, but all of those things take place in the setting of our homes. And in terms of documents, actually, while we're talking about documents, I wanted to thank the GREF for the guidance document that they've produced, because I think that's really helpful. So thanks to the GREF for that. A document that I read with interest was the CRIA, the Children's Rights Impact Assessment. And I do check for these, sir, because they are documents that tell us, of course, the impact on children's rights that a proposition has. And I was pleased to see a really detailed CRIA with the Minister's proposition. And I just wanted to raise some of the points that were within that CRIA document that perhaps members may not have had time to look at, because, of course, I think, and again, I looked through the scrutiny review, and I was quite staggered, actually, at the amount of evidence that was received by the scrutiny panel. But when I looked through that, there wasn't a lot of talk about children and families. And I think, again, that's why it's really important that we do have these CREAs, because it forces us to consider that point of view when, of course, children don't often have a voice in the political sphere. And one of the things that was raised in the CREA was a survey that was carried out by, I believe, the Children's Commissioner. I think it was called the Life on the Rock survey. And housing was found to be one of the top concerns of children. So I think as adults, sometimes it's a huge concern for us, isn't it, if we're looking for a house to live in. I think we've all had our own experiences with that. But children also have those experiences, but they don't have the power to make decisions around that. And some of the children that took part in this survey, they spoke about, and I'll read some of their words, the housing has been crazy too. The first house we rented for 2 years, then we moved to another rented house. And because we were under the impression in the first house that we'd be kicked out, that they were going to sell it to developers to knock it down and end our lease. The second house we were renting and my parents decided they wanted to buy. And it goes on, and these experiences that children have of being moved around, I think universally the children who talk about this feeling of being moved around and almost being powerless to prevent it, it's really detrimental to children. And one of the reasons why I will be supporting the principles of this is that I want to see that reduced, and I think that these proposals will do that, and I think with some of the amendments will do that even more effectively. And I'll stop there, sir, and I think I might have more comments to make on the amendments, but I wanted to thank the Minister and the scrutiny panel for the work that has been done in the hope that we can get to something that is really good quality.
Thank you, Deputy. Does any other members speak on the principles? Deputy Rob Ward.
Thank you, sir. I thought I'd speak at the beginning because just to follow the previous two speakers. I picked up something that was said by the chair of the panel, sir, the comment that was in the report. There was real merit in improving current law. And I think that's the key point, because I speak in strong support of the principles of the draft Residential Tenancy Amendment Law. So this is not just a technical update. It's a moral and practical response to housing pressures faced by thousands of islanders. And we are talking about the day-to-day experiences of thousands of people on this island, particularly, actually it's not particularly. One group that is picked out of that are young people. I've had lots of conversations recently across all of our schools and colleges with young people post-16 and talking about, we asked every single one of the groups, will you stay on the island? And there were some really mixed responses. And one of the issues was around housing. How can they get secure housing for themselves so that they can build their futures here if they don't have that support from elsewhere? So there is a real issue. But it's not just young people. It's people who want to downsize, elderly people who have lived just on a pension, for example, who are facing very expensive rents and no control perhaps over the rises in them. And perhaps some insecurity in their housing at a time of their lives. Well, that's exactly what they don't need. And in the context of Jersey, so nearly half of Jersey's households live in rental accommodation. Nearly half, so it's a significant number. And there have been insecurity, unpredictability, and a lack of recourse. And this law begins to change that. And we have a number of amendments coming through. Some have been accepted by the Minister. The scrutiny panel has done a lot of work on it. There are some, obviously, which I think are, I'm surprised that such significant change were allowed in amendments, but they were, so I hope we don't accept those ones. But I hope we can get through the principles and get onto those debates. So what does the law begin to do? It introduces a framework for rent stabilisation, a concept long overdue in Jersey. And under this law, that means that rent increases will be limited to once a year with at least 2 months written notice. That's the reality of what this law is about. That's not radical, sir. It's responsible. It gives tenants predictability and it gives landlords a clear and fair structure. If you are a tenant it is unlikely that you have significant, well, for many tenants, there is not significant extra money, particularly for young people who may face deposits and so on and come to the bank of mum and dad for those deposits, which perhaps they don't get back straight away. It takes time, so you pay the next deposit as well. They are planning their incomes very much linked to their rents because such a large proportion of it is their rent. So they need time to adapt to any rent change. That rent stabilisation in that form is simple, it works, and I think it is something we should be supporting. So this law also strengthens security of tenure. It requires landlords to provide a valid reason when ending a tenancy. And if that reason is false or misleading, there are consequences. And the Minister introduced those consequences and told the reality of those consequences at the beginning. So people are renting a home. A home is the most basic need for everybody. And that security gives you security in so many places. Many of us may have had experiences of not having that security, particularly when young. And it's not a good place to start your life. It's not a firm basis for how to build for the future. So anything that gives that security, I think is beneficial, particularly for families on the island. But it does not prevent landlords from reclaiming their, well, I've got the word property, which is the home of the person living in it. In fact, it introduces mandatory grounds for eviction, including serious breaches of tenancy agreement, illegal activity, or the landlord's need to occupy the property themselves. These provisions protect landlords from being trapped in untenable arrangements and ensure that they can act decisively when necessary. So it isn't about punishing landlords, it's about protecting tenants from arbitrary or retaliatory evictions, and it's about ensuring that a tenancy agreement means something. When you sign, it means something and gives some protections, given that you may be paying 30, 40, 50% of your income each month. And for me, sir, for the first time, a very important part of this law is the establishment of a rent tribunal, an independent body to resolve disputes. This benefits landlords as much as tenants. It offers a clear, impartial process to challenge unreasonable claims, enforce contractual obligations, and avoid costly legal battles. The courts, sir, are a place where many people will never go to get retribution because they are not set up for that. They are viewed as a last resort, and that is not the place to solve simple disputes over a rental. A rent tribunal can simplify this and be a very beneficial change to our law. And the wider context, so that it will be mentioned, I'm sure, so many times, the 2024 Jersey Opinions and Lifestyle Survey found that 64% of renters who experienced a rent increase in the last few years struggled to meet housing costs. Now, there are thousands, over 20, 30,000 people renting. 64% of those is a significant number. And when we talk about election issues, this is an election issue because people are worried about their homes. And we need, as an assembly, to prove that we have a value to them. And I hope that we can consider that as we move through the principles and onwards. But so that struggle to meet costs is not sustainable. It's not acceptable. And it is driving young people out of Jersey. It's also driving a section of our community out of Jersey, around 40 or 50 with children, who are leaving some of the most skilled people to say, actually, I can survive elsewhere, and I can buy, or I can rent, or I can move just in the same way, and have other opportunity. So the impact of this just is complete. Data is difficult, but it is happening. But if we wait so long as well, let's just record something and do nothing now, it will be too late. I can refer back to the last population policy that came forward, and the detail there was about our numbers increasing too quickly on the island. There's too many people coming to the island. That has changed rapidly within the course of 2 or 3 years, the view on where we are. And these things change rapidly. You cannot afford to wait to make change. So this law is a response to reality. It aligns with our common strategic policy, which was voted for in this Assembly almost unanimously. I think there was one vote against. It reflects years of consultation, as mentioned, tenants, landlord, housing trusts, advocacy groups. It's measured, it's proportionate, and it is deliverable. So it's not anti-landlord, it's pro-fairness. It recognises that a healthy rental market requires trust, transparency, and balance. It protects tenants from instability, but also protects landlords from uncertainty, bad faith, and legal grey areas. And so we have a choice. We can continue to defend status quo that leaves tenants vulnerable and communities hollowed out. Or we can agree in principle and say that in Jersey, your home should be secure, your rent should be fair, and your rights should be respected. And I want to highlight that this law undergone... I would go back to the scrutiny panel because obviously, so I'm a great advocate of scrutiny. I spent most of my career on scrutiny. And it has undergone rigorous scrutiny. The principles were sent back for that scrutiny. We've now seen that, the 286-page document. Fantastic read, so I always recommend a large document. And the scrutiny panel reviewed the draft in detail and found that it aligns with our strategic priorities on housing and cost of living. So it's doing what it needs to. There are amendments to be debated, and those slight changes may be made. That's for later on, but we're at the point of principle at this moment in time. The report supports the law's aims of delivering longer, more settled tenancies, stable rental returns for landlords, and clear responsibilities for both parties. So the legislation is not rushed, it's evidence-based and carefully considered. And so the Assembly decided by a small margin to return to the principles of scrutiny. We're now back with those, and I urge members now to support the principles and then have a thoughtful and considered debate over amendments as they come forward. So thank you very much.
Thank you, Deputy. Does any other member wish to speak on the principles? Tower St Mary.
Thank you, sir. I shall be relatively brief and not touch on the detail of either the scrutiny panel's recommendations, of which I'm a member, or the Minister's main proposals. I would like to stress the point made by both my chair and others by referring to one paragraph in our report. At its core, the amendment law represents a reconfiguration of the relationship between landlord, tenants and landlords. The evidence collected demonstrates a stark divergence in how each group views reforms, approaching them from fundamentally different perspectives on rights, responsibilities and the balance of power in the rental market. And quite aside from the submissions made to scrutiny, I know that members have received direct emails from a variety of people on both sides of the camp, more or less saying vote yes or no. And that actually demonstrates, I think, a lack of understanding as to how nuanced the law is and the amendments are, and it deserves a greater explanation, and that is what scrutiny has set out to achieve. So we are discussing here the principles. Hopefully they will be approved so we can go on to debate in more detail some of the amendments and the provisions. And if any member has misgivings about certain of the provisions, they can vote against that particular point at that stage. We need to get past first base by approving these principles. I do emphasise that. The members referred to the polarisation between the two groups. There should not be a polarisation. A tenancy agreement is of mutual benefit. We need to get united on this, and the Assembly needs to assist in that unitedness. And I suggest so that if we reject the principles, that will be a black mark against the Assembly and will be taken as a lack of respect for the electorate, if not scrutiny. Thank you, sir.
Thank you, Conrad. Does any other member speak on the principles? In that case, Deputy Scott.
Thank you, sir. If you're going to drive a car that's about to crash, remember only one person is driving it. I refer to Deputy Catherine Curtis's speech. I have an interest in islanders being properly housed and supported because this is important to the economy. In turn, the economy supports them and all islanders, and the economy needs to be supported. And I accept availability and quality of housing supports the economy. But this law, in its current form, does not support widespread availability and quality of housing, owing to our current economic environment and the state of our housing market. It focuses on redefining rights of a potentially small and unspecified number of individuals, with the aim of supporting them at the expense of the long-established property rights of many. There are many ways to crack a nut, sir, and I sympathise when Deputy Barbara Ward describes it as a sledgehammer. These proposals have been developed and scrutinised in a silo, in the absence of an economic impact assessment. The Minister was provided with one by Government's Economics Unit last week, which has set out the issues. It subsequently was shared with the Council of Ministers through official channels yesterday. I do not know if the Minister has shared the economic impact assessment with his scrutiny panel, but it affects their position on available economic advice to which they referred in their report. This law won't solve the issue of unaffordable rents, which I have to say was why it was of interest to me in terms of my own engagement with my own constituents. I have been very much concerned about unaffordable rents. But it won't solve it because the problem is an economic one. Rising costs are nothing new, and they are happening everywhere. And in our own island, we have a problem unlike anywhere else that makes rising rents unaffordable for quite a few. And that is the far greater extent to which inflation has grown more than businesses in the island. This has meant profits and wages have not kept pace with inflation, and therefore that is a major factor in terms of people not being able or struggling to pay rents. And sir, I would dearly love to be introducing or supporting measures to magic up an economic transformation of this island, which I dearly would love to see. But I am an assistant minister whose delegated role in the economy lies elsewhere. And the Minister for Housing isn't responsible for improving productivity either. He has been working in a silo. However, bringing in measures that don't support the economy by not helping with widespread availability and quality of housing is counterproductive to his very own objectives. The economic impact assessment, to which very few of us seem to have had sight, unfortunately, has pointed out how this law, in seeking to support tenants, has created significant reasons for landlords to divest and for others not to invest in buy-to-lets. High interest rates, increases in stamp duty, the proposed removal of mortgage relief, the extra costs of compliance with the proposals, and indeed the Economics Unit did do a calculation in this showing the expense for landlords. This negatively affects the availability and quality of rental properties for your and my constituents. And I, for one, don't want tenants to be forced to tolerate relationships with unsympathetic landlords. I want them to have more choice. And indeed, there are many other ways of supporting them, whether it's greater availability of social housing, and indeed that is quite a major part of the market, or at least rentals. So a lack of supply can exacerbate the issue by depriving them of choice. This law, because the scrutiny panel's report has been mentioned and certain content of it, and I'm going to emphasise something very much. It's overly complex. It's seeking to support people in a way that is more complex than is necessary. And in that respect, you may also call it red tape along with the obligations of landlords. So I would actually say that in terms of the Common Strategic Policy, there are some issues there. I try and think, how did it end up so complex? How did we even end up in a situation where right now we're debating this law without having had the information that I believe that all states members should have been able to take into account? And as I've mentioned, part of the problem is silo. But look, I would actually say it comes down to this. There wasn't really an agreed problem statement. We had the Common Strategic Policy saying we'll improve arrangements for both tenants and landlords, but we never actually said, well, what exactly is the problem? How are we going to solve this with a single law? And instead, what we've actually found is that the minister has suggested that there is a problem, and not everybody can say, well, that is the main problem here. And indeed, some aren't even aware of it. I personally have not had any constituents come to me and talk to me or complain about revenge evictions. I did mention this to the Minister for Housing, who said they don't go to you, they go to the Citizens Advice Bureau, which I thought was quite interesting. So I find it somewhat ironic that the Deputy Kovash asked the Minister for Housing yesterday what steps he was taking to counter misinformation. I mean, the reported response of the Minister to the States members' decision to delay this debate was, at least this is what the press report says, the delay was down to cowardly politicians as a deliberate act of sabotage driven by vested interests playing dirty tricks, and that this is what happens when you have politicians who don't have the courage of their convictions. Well, I have the courage to say, I don't believe that really was an acceptable way to respond to a proposition brought by a deputy in the Garda who at the time, and it's recorded in Hansard, explained her reasons for bringing that proposition. It was to enable more information to be available to states members because they were actually deliberating what could they support the principles or not, did they have enough information? And even now, that information eludes many. So the Minister did not respond to the delay of the debate by saying, I will seek to accommodate members' concerns. And much of the problem with the complexity of these proposals, and I perhaps will give a moment to go through this sort of logic, the way that I've tried to, in my discussions of why I have personally tried to amend this or bring an amendment to this law, what the kind of logic has almost been. It's been, well, I want to make things more secure for the tenants, but then on the other hand, I want to let them get out in certain situations. And all the time I said, okay, just explain to me, what are the courts doing that is wrong? There are court mechanisms that support people in these circumstances. Is it that tenants don't know their rights? Because, as Deputy Balash says, they cannot be evicted other than by order of the court. And even when you look at the order of the court, if a landlord brings proceedings about rents, they can rewrite the contract. The court is there to look at things from a case-to-case basis and actually provide relief for tenants. In this general framework of allowing people to dispose of their properties with relative freedom, the court is there to dispense justice, but instead, I find that what's happened is that it's almost like the minister has decided, okay, I'm going to decide what's fair. And some of the questions I've been asking him that I still haven't got an answer to, but he might well choose to do so in his speech, is what's so fair about preventing a landlord to terminate a lease in accordance with its terms to provide a home for a beloved and disadvantaged niece or nephew, because I don't believe that's in the reasons that he thinks are acceptable. I mean, as opposed to a grandparent who may have abused them in childhood. What does he know about these personal circumstances? What is fair about preventing sophisticated contracting parties, such as multimillionaires who want 5-year fixed-term contracts? What's fair about preventing them to make their own judgments on what is fair? What is fair about forcing the policy judgment of the minister or rent tribunal members on what is fair in parties in substitution for the courts dispense on a case-by-case basis? What is fair about depriving the court of jurisdiction when considering rent matters, and if the rent tribunal hasn't been involved, to actually exercise its discretion? What has been wrong with it? Because if that's been part of the problem statement, I really would have liked to have known. It's never been presented to me as part of the problem statement. What is fair about introducing measures that would make every rental property a form, and I know that the minister will take issue with this, like a kind of social housing, because what I mean by that is that basically you have to rent on the terms that the minister thinks is fair in terms of you terminating, you exercising things, regardless of the court. I do find that there are I have some difficulties in comprehending all this. What is fair about disincentivising investment in buy-to-lets that will impact on the choice of property available to tenants and lead to further economic contraction, quite possibly, that could hurt our own community? What is fair? So I come back to, because I seem to have gone into the whole area of misinformation, the scrutiny has pointed out the lack of certainty created by the minister's proposals and the increase of his ministerial powers. And what we see is there's been a lack of joined up and systemic thinking, and that creates risks for islanders' well-being if the minister is supported in pursuing his current course. I did work on an amendment in the absence of an economic impact assessment being prepared and shared and being part of the information available to scrutiny and to states members. And I have to say, and I would have enjoyed my summer much better if I'd actually just jumped off this vehicle before it crashed into flames. And I think some people will say, well, is it still safe to drive if my amendment is accepted? And I would say, yes, it won't be perfect. I know that the minister's already kind of like beginning to scoop out things where it could have been better, and likewise, I can pick holes in his. Hey, extortionate fees for leases. How come we're still actually allowing that to happen? Because basically, that's one of the things that was raised by scrutiny. I haven't solved it. They haven't solved it. I kind of thought he might pick it up and solve it. But, you know, I mean, as I say, people will be saying, well, what are you being involved in all this anyway? Other than I really was concerned, I wanted to come out with something positive on behalf of my own constituents. Thank you, sir.
Thank you, Deputy.
That's the speech.
Deputy Alex Curtis.
Thank you, sir. Scrutiny has conducted a thorough review of the law, and I can keep my comment on the principles brief, as the Conotub of St Mary covered most of what I wanted to say. The most important point, I think, is that the argument put forward by some to us in exchanges, as the Constable said, has been one of for or against the principles, and the reality is, unfortunately, but expectedly nuanced. I personally believe that we found through our review that many policy decisions in the amendment law are just that. They are policy decisions. Some are being made in the absence of evidence. That is not necessarily something one can blame the Minister for, because evidence may not exist for that, but they are nonetheless policy decisions he is intending to pursue. For example, the move to periodic tenancies as a requirement after the first term was something our expert advisor could not confirm was the best policy decision. In fact, he offered us a range of, I think, 5 recommendations members can read in the annexes that could both retain this as an option or revert to something different. And this was down to the fact that this is a decision as to how we wish to structure the law. It wasn't inherently better. And for me, I see a concern under moving to forced periodic tenancies. We heard through a lot of responses to tenant surveys that they want security and flexibility. Landlords, we also heard, as our chair said, want to know they have a level of control and certainty. And the question still remains whether under a periodic tenancy systems, tenants will have more security or not. And it depends on how one defines that security. For example, under a periodic tenancy forced on a tenant and landlord, the tenant will never be more than 3 months away from a potential need to leave the property, because the landlord will have been granted by that tenancy under the law reasons to give notice. And in all likelihood, the reasons a landlord might give are those that they would have given to not renew a fixed term, such as sale of property, renovation, or occupation. Meanwhile, in a fixed term tenancy, as we heard from submissions, being the majority form of tenancy on the island, many tenants will have security of tenure starting at least 12 months, winding down to their date of renewal. And parishioners of mine who have long-standing tenants highlighted examples where they have tenants who wish to invest in the property for home improvement or garden improvement to make it a place to live. And they in particular did so because they were granted 3-year tenancies. These are tenancies without break clauses for the landlord that are not unilaterally supportive of the landlord. And if we have a chance in the articles, we will have a chance to debate improvements the scrutiny panel saw fit to cover this area, and we will touch on those later. Likewise, on rent stabilisation, an RPI increase could help cap rents. But personally, I'm concerned that these will lead to rents tied to RPI in all instances. And it may be a case that for some tenants and for some types of tenant, this is a better solution based on their type of landlord, whether their landlord was a poor landlord. But there are tenants who will face greater regularity of increases than they do currently, because landlords are quite happy to be below RPI to secure a comfortable sitting tenant. However, the panel has clearly found a number of measures proposed that are valuable and evidenced. Data collection, notice periods to avoid silent non-renewals, greater clarity on fees and charges, to name a few. As I say, though, nonetheless, some of these areas covered are clear policy choices, and it is for members to decide whether they think that policy direction will improve the balance for landlords and tenants, or, in the greater scheme of things, not. Fortunately for members, we have, albeit in a complex way, a chance to bring forward changes to the extent that we desire. Deputy Balash has proposed a fairly fundamental amendment, splitting out multiple sections of the law. This, whilst not perfect, provides members a chance to express where their policy position lies. The panel is clear there is room for improvement. It is for members to decide where to take that. I would reiterate that by highlighting that the panel has proposed an amendment to Deputy Balash's amendment. which would ensure that the law can move forward and members can choose which way they vote. Deputy Balash in his speech said that we should agree to the principles only if we agree to the general thrust of the law, and that is a very principled way to do this. And we debated the definition of the principles back in July. Whilst I have frustrations and misgivings with parts of the law that I will vote against should we get to the articles, and I will look to retain certain positions, I do see a need that we signal that this law can continue to change and there are areas to improve. I highlighted, and although it may seem minor, data collection, a debate as to whether an RPI cap is right and the evidence could be collected will require data collection. The Minister's proposed mechanism for collecting this data is through the rented dwelling licensing form, and I remind members that most applicants will have done that in around May to June last year, and the next period for data collection will be in less than 12 months. If we do not create a mechanism now to change the law to collect that data, our ability to make evidence-based data collection to inform whether we need an RPI cap, whether rent stabilisation measures are appropriate or could hurt, will be a debate we will have to have further in the future, not sooner. So I would like to be able to have that debate in full. I do believe that there are parts of the law that can be accepted, and as such I'll support the principles, but be making my points again as to which parts I will not be supporting in the articles.
Thank you. Deputy Wilson, your light was on briefly. Yes.
Thank you, sir. I'll be brief. There's a number of points that people have already made that I won't repeat. But I think we all agree that the principle that tenants deserve security and landlords deserve clarity isn't in dispute. But the question is whether these proposals, as they're drafted, deliver a balance, that balance that people have talked about, or whether or not they risk creating new problems. I just wanted to pick up on Deputy Ward's comments about rent stabilisation and that any increase in rent should only happen on an annual basis as a better solution for those who are renting. But he fails to mention that some landlords choose not to increase rents annually, which I presume for some tenants would be an advantage. We haven't seen the data which tells us how many times landlords do this, or indeed how many of them do it. So could it be the case that the principle of rent stabilisation as it's proposed is that we are in danger of building into the law a mechanism for increasing the annual financial burden on tenants? And I would suggest that in strengthening some of the principles behind this proposition, that some data modelling would have assisted our understanding of the impact of that principle, which I believe goes to the fundamental heart of the landlord and tenant relationship. Deputy Mezek has agreed to removing the 5% cap because he thinks there will not be an increase in RPI above 5%. If this principle was key to his proposition, then why has he changed his mind so quickly? And it would be good to hear what his thinking is now on the measure to be applied, because it feels to me that this is lawmaking on the hoof. He says restricting reasons for ending a periodic tenancy enhances balance, but when landlords are left with virtually no flexibility, that cannot be balance. It is actually a disincentive to let a property in the first place. He says that a 12-month minimum period protects tenants, but is it fair or even practical on a small island where family, financial or business circumstances can change overnight? The principle we should be upholding is fairness, but for both sides, not creating unintended consequences in an already fragile housing market. This draft amendment law risks tilting too far, and if landlords walk away from the market, tenants will be the ones who will ultimately suffer. So it's my view that we should be aiming for protections that are proportionate, workable, and genuinely balanced, because principles only mean something if they actually work in practice. The principles, as we've talked about, around clarity, fairness and balance are actually sound in theory, but in practice, in relation to the way in which the law is proposed at the moment, they do risk creating rigidity, complexity and imbalance,
while failing to address the wider housing affordability and security issues in the island at the moment. And I just want to say that housing is not just a contract. It's a social necessity. It's tied to health, it's tied to security, and it's tied to dignity. And if we don't get the principles right, then we're building instability directly into our society and our economy. I agree with Deputy Balash that the amendment law as it is written is the wrong starting point at a time when we should be addressing affordability, stability and fairness in the rental sector. We cannot rely on a framework that ignores these fundamentals. I cannot support the regulations on first principles because they're built on the wrong foundation. I believe that we deserve a housing law that at the same time meets our economic reality as well as protecting our people. And I'm afraid these regulations as written do not do that, and I cannot support them.
Thank you, Deputy Wilson. Deputy Renouf.
Thank you, sir. I'll start by saying that, like Deputy Mesic, I wondered how best to approach this debate, given the speech that I made last time. His first thought was simply to refer members to his previous speech. I'm sorry to say that my first thought was simply to read out my previous speech. But happily, like Deputy Mesic, I have had second thoughts. So I just want to reflect a little bit about some of the history around this, because housing is a significant issue in this island, but it's part of a bigger picture. I think you could say reasonably that the central issue we face as a democracy is that on average living standards have essentially not risen in, let's say, Western democracies, for the sake of argument, for 15 or 20 years. We can quibble about the details of that, the exact dates and so on, but in Jersey, as in much of the developed world, the financial crash marked a turning point, and we've never really got fully back on track. Of course, many people have got better off in that time, but taken as a whole, living standards have been squeezed and remain squeezed. I think this is not a good situation for democracy. People feel anger because their lives are not getting any better. And what's worse, they can't see how their lives or the lives of their children are going to get any better. And we see the results of that in the rage, the frustration, the impatience around political debate. And we see it in the grasping at seductively simple solutions, Brexit, tariffs, attacks on immigrants, and so on. And we see it in the popularity of politicians who feed the public those simple solutions. So how do we respond in Jersey? How do we make a case for improving people's lives without resorting to political extremes, which is, I have to say, where I come from? Our options are limited, actually, partly because we are a small island, lashed by economic storms over which we have little or no control. But also we have self-imposed limits. The Jersey model is based on low taxes and stability. Redistribution, except at the margins, is not something this government, although taken as a whole, I know there are exceptions, redistribution is not something we tend to consider. Actions have actually been taken during this term of office to improve living standards. The government of which I was a part significantly increased tax allowances and raised benefits. At the same time, this government has increased the living wage, amongst other things. These are good steps. But I'm afraid the public have banked them and noticed that their lives are still squeezed. We need to do more to improve the lives of that very significant section of the population who are under pressure and for whom Jersey is not currently delivering. These people are concentrated to a significant degree, although by no means exclusively, in the private rental sector. And there are, of course, two dimensions, at least, to the stress of those who rent: rental stress and insecurity. If we look at rental stress, statistics Jersey say that more than 80% of low-income people in private rented accommodation are in rental stress. They also say that in the 8 years to 2022, rents increased well ahead of earnings. Well ahead of earnings. There has been a small correction since, but nowhere near enough to compensate for the increases over the previous years. Therefore, improving the conditions for renters and ensuring that the rental sector works for tenants and landlords is important. I think, so we come to the question of these principles and the extent to which they may or may not help. The fundamental point here is you start from a point either of thinking that change is necessary or you think it is not. Deputy Balash was very clear that he does not think it is necessary, that the current laws are sufficient, and some other members have echoed those points. I come at it from the point of view at the basic level that change is necessary and desirable, and that therefore we should support the principles and get into the detail of which particular bits of the proposals will help and will not. But I think to stand here and say that the current situation is completely tickety-boo is really not plausible, and it is not what people in this island who are struggling would expect of this assembly. I think they will expect us to engage in some reasonable debate about some detailed measures that might improve their situation. And that is what passing the principles will do. It does not commit us to much at all in terms of the actual details, because we have amendments down that would remove an awful lot of the substance of this, but it would at least, in debating that, suggest to people that we take seriously the situation in which they find themselves. We take seriously that they would like to see improvements. And I do think, with the greatest of respect, that to argue that it is not necessary to improve the current situation is, I think I would say, naive. I think we do need to offer improvements. I do have some sympathy for the Minister. He's been told that, and the scrutiny, you've been told that the proposals or things they've written are overly complex. I suspect that had they produced a shorter, much shorter report, it would have been criticised for not being detailed enough and not anticipating all the issues. The accusation was made that the Minister doesn't understand what the problem is. And I think that's a bit unfair. I think it is true to say that no one really knows the full, exact contours of every detail of the problems that the rental sector faces. But I think the Minister knows its shape and its scale and has correctly identified it. I think it is perhaps willful to ignore the evidence that has been built up over the years to suggest the problems in our market, whether that in our housing market, rental market, whether that's media reports, the scrutiny report, the evidence cited by Deputy Doublé in Life on the Rock, evidence presented by charities, and so on. There is plenty of evidence there to indicate that there are problems which need addressing if we open our eyes to see it. I do want to address this question about whether there is really a problem. And the allegation has been made by some people that the Minister has invented a problem, particularly in terms of revenge evictions and so on. And I think maybe the term revenge evictions doesn't help here, I don't know. But to my mind, the issues here are twofold. It may well be the case that not many people are told by their landlord, I'm kicking you out because I'm ending your tenancy early because you have complained about something. That may well be the case, but they don't have to, under the present system, do that. They can simply wait for the tenancy to end, which will be a short-term tenancy because that is what we mostly have, and then not renew it. And not renewing a tenancy is not an offence. No tenant can take a landlord to court for that. The landlord doesn't have to give their reasons for not renewing. That is the hole that sits in the heart of our tenancy arrangements. So it is completely impossible to say to what extent that happens because, I think the Minister says it right, by design, the law does not allow us to identify that problem. However, We have been told it by an awful lot of people. I've been told it by constituents in various forms. A form which says, you know, look, I'm just not prepared to put in a complaint because I need this roof over my head. And it may be that if the argument is made, well, you know, increasing supply will solve the problem, but not necessarily. There are many problems with that argument, but one of them is that maybe people want to stay in the house in which they're living rather than have to move somewhere else. And that is something, as owner-occupiers, we take for granted, of course. So I think there is sufficient, more than sufficient evidence to say there's a problem. That in itself would justify us approving the principles and moving to debate the detail. It is also the logic of the decision that was taken in July when the Assembly asked scrutiny to go away and look in detail at this. Scrutiny have done that, and they've come back with some very detailed and quite sophisticated responses to this. And it would seem to me to be perverse for this Assembly to say that we should send scrutiny away to look at this, to do detailed work, and then say, well, we're not going to actually debate anything of which they have done. I think a minimal position which this Assembly could adopt is to pass the principles and at least get into that debate. There's been questions raised around Deputy Mezik's style, and the question of whether that has helped or not is, I think, moot. We are not voting on his style. We are voting on the words within the proposition and the amendments that he has indicated he will accept. Whatever language he has used, his actual actions are, I think, reasonably significant. He has moved. He has accepted amendments, and I thank him for accepting the amendment that I put forward, and he's clearly explained why. I think there was an accusation made that this was making up policy on the hoof. I think that would be kind of how can you win? If you reject amendments, then you're intransigent. If you accept them, then you're just making it up as you go along. I think I would prefer, having been briefly a minister myself, to be given credit for meeting people halfway. The final point, perhaps, it's been talked about that the fall in rents is a cost, 100 million cost to the economy. It's not a loss in the sense that that money has disappeared from the economy. It's disappeared in terms of landlord income, but it has reappeared in the pockets of tenants and for them to spend. And that is a distribution issue, not a size of the economy issue, I think. And in any case, I think it is, as I said earlier, the rise in rents has been very, very significant over the last 8 years, and the corrections that have happened since then do not unwind those rises. And I think for that reason, I do not think that that is a reason to reject the principles. So I think overall these are pretty moderate proposals, particularly when the amendments that the Minister has accepted are taken into account. If we're not going to take action now, what are we saying to those people whose lives are under pressure, whose housing situation is precarious, who are vulnerable because they are on short-term tenancies, no matter how long they've lived in a property, and a landlord can simply not renew their tenancy? We're not even going to address this problem. So I think we do need to shift the terms of trade in favour of tenants. I know some landlords are resistant. Change brings uncertainty and may make life more difficult for landlords, but I think that is landlords who may be acting unreasonably. Some tenant gains may come at a cost to landlords, but I don't think most will. Most of them have minimal impact on landlords, and there will be some gains for landlords, which I think is important to remember. Not everything is a zero-sum game. So I think we can make the situation better for both landlords and tenants. The exact detail of how we do that depends on how we approach the articles, but not passing the principles would be a huge kick in the teeth to people who have asked for us to consider this matter, and indeed, I think, perverse given the actions of the Assembly in referring this matter to scrutiny.
Thank you, Deputy. Does any of the members speak on the principles? I I invite the Minister to reply. Deputy Kovac and then Deputy Miller. Deputy Kovac.
Thank you, sir. I want to begin with what bothers me most in the opposition to these regulations, and I want to highlight this clearly for my States members colleagues, for those in the gallery, and for the public listening online. When a landlord purchases and owns a buy-to-let property, it is an investment, a deliberate choice made to generate income or capital growth. It is not their main roof, it is not a charitable act. It is a business decision, and like any investment, it carries both rewards and risks, including rising mortgage rates and costs, and should not be expected that all cost increases would be carried by tenants. The issue is the tenants are increasingly being told that their rent must go up because the landlord's mortgage has increased, their X and Y costs have increased. However, if the market value of renting such property is the same, the tenant doesn't receive nothing extra or enhanced or needed refurbishment, that's fundamentally unfair. The tenant did not choose the property, the mortgage terms, or the investment. They are not co-investors. They are simply paying for a place to live, often their only option for a roof over their head. Tenants already carry their fair share of responsibility. They pay rent, often upfront deposits, and they're expected to look after the home. If they damage something, of course they should cover it. But general wear and tear, maintenance, that's the landlord's job, and the cost of that should already be baked into the market rate of rent to start with. When interest rates drop or a landlord buys the property in cash, we don't see those landlords rushing to reduce rent, do we? So why should tenants be asked to carry the weight when rates go up? This is why it matters to set the record straight. In competitive markets, the going rent is set by supply and demand, not by an individual landlord's costs. A tenant doesn't pay because you spent money on insurance or renovations. They pay because they value the use of the home at the market price. That principle applies whether it's flats, cars, storage units, or equipment hire. The owner takes the risk and bears the responsibility. The consumer pays for use, not ownership. Landlords benefit long-term from property appreciation, from rental income, from tax advantages. The property is theirs. The mortgage is theirs. The profit is theirs. So too should be their responsibility. Rent should reflect the value of the home and the market, not the landlord's personal financial gamble. If you can't afford to sustain your investment without passing unpredictable costs onto someone just trying to live, maybe it's not the right investment, and maybe they should sell. It applies to any type of investment as it applies to housing as investment. And guess what? If landlords do sell, those properties don't go into thin air and disappear. They either make some of the tenants homeowners or go to other landlords, so that part meant to scare and over-circulated, that all landlords will leave and there will be no more rental, no more housing, and all rents have already increased because of it doesn't stand. I've been lately checking home selling and rental websites and related social media posts, and yes, housing in Jersey is expensive, for many unaffordable. Rents in Jersey are expensive, but there are plenty available currently, both to buy or to rent. To summarize what I found, I'll quote one of the comments from a public member on a related thread, and he says, "I moderate the largest rental forum in Jersey, over 23,000 membership, and I know that rents are not going up but down. I also know there are more rentals on the market than there were only 2 years ago. Just remember when you post false information online to justify your point, there are people here who are actually fed information on this daily." I welcome the fact that the minister has accepted an amendment to compromise linking rent increases to inflation instead of the 5% limit. This is a balanced, reasonable approach. It ensures predictability for tenants while still allowing landlords to maintain fairness in line with the wider economy. And I want to highlight that more landlords should think like a landlady from my constituency who wrote to San Xavier Deputy this morning in support of this proposal. Let me read some of her words directly. "I'm emailing to ask you that you please vote for Mezek's proposed housing laws today. I support a just and equitable society, and these proposals are in alignment with this. I myself, a landlady, but still see the justice in this proposal to support tenants. I also work in mental health and see how these proposals will increase protection and housing security, as such protecting mental health or those perhaps already most vulnerable. In terms of the economic argument, I believe supporting this proposal will support our local economy, as it is well known that those with lesser economic means tend to spend locally the most. His proposals seem fair, just, and reasonable. Please side with what is good and proper, and as always, as I am, beyond self-interest, which all need to keep an eye off for strengths of character. That is the voice of a landlord, one who understands the fairness cuts both ways, and that housing security is tied to community well-being and even mental health. I would also add to this email, and in response to Deputy Scott's speech, that economies only exist if there are people there to spend money. Now, I honestly struggle to see why good landlords would have any real objections to these proposals, except for the scaremongering seen spreading misinformation about their impact. I'm very lucky to have had the same great landlord for over 10 years, and who already does all the right things set out in this legislation. For landlords like mine, nothing will change. But for tenants facing bad landlords, this protection matters. Jersey Landlords Association say there's only anecdotal evidence of revenge evictions. But I invite them to scroll through social media from the past few years, speak with charity organizations, or ask us, state members, past or present, because many of us have been directly involved with or heard of at least one such case. I personally dealt with quite a few during my time in Jersey, both through community work and in this assembly. I have also witnessed it happening to close friends whom I supported step by step through the process. These cases occur far more often than landlords are willing to admit. Even if there were only a few cases, which is not true, the fact that we could prevent them means we should act to do so. That is why I found Deputy Ballard's speech remarks patronizing when he said that the minister had invented revenge eviction term. I sincerely hope he or any close to him never have to face such a situation, because these cases are very real, either expressed directly or indirectly to the tenant, and deeply distressing for the families and tenants who experience them. At the same time, nobody denies there are bad tenants as well. The data is just as anecdotal, but we know that they exist more than is believed. Landlords rightly want those issues addressed, and this law allows for exceptions to deal with them, giving also reduced notice in such cases, and there's the petty debts court to deal with. But what too many landlords try to deny is that the other side also exists quite often. Bad landlords, unfair rent hikes, and revenge evictions. Those too must be addressed, and that's what we are debating today. We should keep the roles clear. The tenant pays for a home, not the landlord's financial gamble. Fairness comes from competition, choice, and accountability. This law proposal reflects the balance. It's fair, it's reasonable, and it deserves member support. Thank you.
Thank you, Deputy. Deputy Miller.
Thank you, sir. Sir, I didn't speak in the debate in July because of the referral back. I do, however, find I still have my notes, and I'm going to use those notes rather than redo, so I'm sorry if there is any duplication. Sir, in principle, it's very difficult to oppose enhancements to tenants' rights. As a principle, tenants must be treated fairly. But in my manifesto in election, I said that I would support legislation that was fair to tenants and landlords, and I think we must be clear that we are not creating an unfairness towards landlords, because despite Deputy Kovac's comments, we are still talking about property. Landlords have human rights too. They have the rights to their property and to use their property as they see fit, although they should do that in a fair and reasonable way. I know from experience that there are bad landlords out there because I have seen the properties. I also know that there are some very, very bad tenants because I have also seen the photographs and I have seen the state in which properties are occasionally left. And I would say that I've probably been approached by more landlords than tenants in respect of this. I think we do need to be careful about our terminology. as Deputy Balash says, eviction is a court procedure, which is very difficult, and there are some landlords out there who really, really struggle to get their property back because of the way our system works. Equally, there may be tenants who are given unreasonable and short notice, and that does need to be addressed. So there's a couple of things that I want to say. A few members, I think both in July and today, have commented about the fact that tenants want and need security of tenure. So do landlords. Landlords want security of tenure. It's not unreasonable for a landlord to be able to assume that if a tenant signs up to lease for an agreed period, the tenant will remain in that lease for that period or give the agreed notice. A lease is a contract like any other. It's a legal document. And it is right that the term of the lease and the provisions on which you can terminate and the provisions on which you can terminate early are clearly set out. But if that is the case and everybody knows the agreement they're going into, that is not unreasonable. I absolutely accept that if a tenant does want to finish a lease early, punitive terms are not acceptable. Punitive penalty terms are generally not permitted in Jersey's contract law, but it is not unfair for the landlord to be able to recover any costs and inconvenience of an early termination. It's also not for a landlord to have to underwrite life trauma on the part of a tenant. A landlord makes a property available to a tenant. You know, it's a fairly straightforward arrangement. I would say that what a landlord wants is a tenant who will treat the property well, who will pay the rent on time, and who won't disturb the neighbours. And the tenant, for having complied with those obligations, has a reasonable expectation that they will be left alone to enjoy the property and live in it peacefully without interference by the landlord. Neither of those things are unreasonable. But there seems to be a view that landlords have just got to deal with situations. And what I would say, the argument seems to be, tenants want security of tenure, but only for as long as it suits them. And then they want to be able to get out of the lease whenever if things change. And to go back to the example that Deputy Mezek gave in his speech today, which he also talked about in July, a young woman who enters into a lease with a boyfriend, all's going well, they renew the lease, and then the relationship breaks down, as I think Deputy Mezek's words were, and she is left with a lease that she can no longer afford. And the landlord, we are asked to believe that the landlord who says, well, I want to recover my costs, I want to apply the terms of the lease to allow you to break this early, is painted as the villain of the piece. And we clearly don't know the whole story. But the boyfriend, who has gone off, presumably, and left her with this lease, he is being let off his obligations under that lease, and the landlord is expected to underwrite the boyfriend or whatever. You know, when relationships break down, people have to deal with those in terms of contract. Had they entered into a purchase, if they had entered into a mortgage and bought a flat, that would have had to be sorted out. You wouldn't go to the bank and say, my relationship's broken, can you let me off with the mortgage? Deputy Andrews is asking us to bring forward binding pre-sale contracts. Now, what if that couple had entered into a binding contract to buy a property and then the lease had broken down? Would we be criticising the seller for saying to the young woman, well, you have got to go through with it and let the partner off the hook? You know, everybody has obligations, and parties to lease have joint obligations, and those joint obligations should be observed. It's not necessarily the landlord's role to deal with matters like relationship breakdown or to bear the cost arising from those. In the employer-employee relationship, a long-serving employee has to give longer notice than someone who's been there for a short term. It doesn't seem to me unreasonable that a tenant who has lived in a property for a very long time should also give a longer period of notice to their landlord than someone who has been there for a short term. Again, that just seems to be simple fairness. I'd also just like to comment very briefly on some things that have been said today about lobbying. People are allowed to lobby. Trade groups, representative associations, that's what they exist to do. They exist to lobby, and it's not unreasonable for any group to lobby states members asking for our support one way or the other. And I do think we need to be very careful that we reject lobbying from one group and just let another carry on. I certainly received a number of emails, which I found quite astonishing in July, from members of Unite the Union who had asked their members to lobby. Now, why Unite the Union should be getting involved in something like this, I'm not quite sure, but they are a representative body, and if they feel that it's something that is in their right, they can ask their members to lobby, or they can lobby on their own behalf. But I think we need to be careful about being critical of people who lobby unless those rules are applied across the board. So the thing that I possibly do have the greatest concern about, and the Minister has said he, I believe, is going to accept Deputy Reniff's amendment, which would remove the proposed 5% cap, is the question of rent restrictions. Prior to our hearing in July, I was challenged at some length by a Corporate Services Scrutiny Panel about inflation and what was government doing about it. There is a real risk that any form of restriction will become inflationary. Any cap will very quickly become a floor. And I mentioned this in another context in July. So just as a reminder, there was a consultation some years ago in the UK where the banking regulator or the relevant regulator was wanting to apply maximum interest rates. They were trying to say, you cannot, as a lender, charge interest of more than this amount. Now, the amount was going to be quite significant. And the banks resisted that on the basis that there are unscrupulous lenders who will charge the maximum as a matter of course. And you can see that that's happened in universities in the UK. You can only charge a maximum of £9,000. So they all charge the maximum, regardless of the standing of the university, it seems to me. By making any limit, many landlords I have spoken to have said to me that we don't make annual increases. We may go for years without making increases. We may make small increases. As soon as you put a restriction, it is kind of human nature that people will apply an increase to the maximum permitted. If RPI is standing at 4%, there may have been landlords who have very long-standing tenants who they are really happy with, but who they may have only charged 2% increase. But because there's a restriction, and the next year they may not be able to charge an increase or a smaller increase, they will charge the maximum increase. It may be best practice to apply RPI in some quarters, but there will be landlords who don't. But I think the prevalence of increase and the prevalence of RPI-based increases will become very, very common. That may be inflationary, and I think that there may be a real risk that it will actually inflate rents rather than control them. I think there is also a real risk that before the restriction comes in, there will be landlords who will put rents up across the board because it's their last chance to do so before restrictions come into place. That's just kind of, you may call that exploitative, you may call it, there may be any kind of adverse word that you would apply to it. But landlords may say they are simply being cautious because if they can't increase rents to reflect their costs, or if they think they may have to go to tribunal and justify rent increases, they may well increase rents on a precautionary basis before the law comes into play. So I do think we need to be aware of that risk. I'm sure that particular point we will discuss at further length in due course. And that is probably one of my major concerns about the articles. So that we can discuss when it comes to the articles. So thank you, sir.
Thank you, Deputy. Deputy Iyer.
Thank you, sir, and I'm very pleased to follow the previous speaker. It will come as no surprise to members to learn that I have concerns about this proposition. Although it is being brought by the Housing Minister, it is almost certainly a Reform Jersey proposal. And as such, its intentions are twofold. Firstly, it wishes to manipulate the housing market by attempting to control rent increases through the repurposed rent tribunal. And secondly, it hopes to decrease the number of landlords by making it unviable to continue renting their properties, leading to a possible sell-off of rented homes in the expectation that they will be purchased by first-time buyers. The use of the rent tribunal has failed once and will inevitably fail again. If rental increases are refused by the rent tribunal, this will lead to an extenuation of the current subdued housing market, whereby property values will become stagnant for a number of years before the realisation that the cause of this suffocation of the market is because of the Minister's manipulation of it. It leads to a loss of confidence in property as equity and can also lead to negative equity amongst those young people who have recently purchased their homes. There is a misconception held by some that all landlords make huge profits at the expense of their tenants. But if I was giving advice to anybody thinking of making an investment in anything, the one thing that I would advise against would be buying property in Jersey for the purpose of renting. Making a similar investment in stocks and shares, currency, gold, cryptocurrency, virtually any other investment portfolio would almost certainly yield better returns. We have to accept that a great deal of landlords are people who have inherited a property from their parents or relatives, and because of the personal connection to it, they do not wish to sell it, but rather they will rent it out and keep it as a rainy day fund for when a sale is necessary. Under this proposal, even the selling of one's own property will become a complicated affair. We are told that rents are rising at an unsustainable rate, and the availability of affordable rental properties has failed to keep up with demand. But how do we compare with other equivalent areas? In London, where property prices are similar to ours, average rent has risen from £1,660 to £2,100 over the last 6 years, far exceeding the levels that we see here. If this proposition is successful, where might Reform Jersey target their next market manipulation? We could face tribunals for all types of commercial activities, and we would be on the slippery slope to total state control of pricing, something which I strongly disagree with. It has become almost de rigueur to bash the landlords while at the same time trying to encourage people to invest in Jersey. We must be very careful about what message we send to the business community, and I advise against continuing down this road. Thank you, sir.
Thank you, Deputy. Does any other member speak on the principles of this law? Yes, Deputy Gorst.
Thank you, sir. At times during this debate, and I think it was the same when we debated in July, there's been use of quite emotional terminologies. We've had suggested that those lobbying were lobbying because of vested interests. The inference, of course, being that a vested interest lobby or point of view was to be disregarded because it was or is self-interested. And that, of course, is perfectly, I suppose, acceptable political dialogue. I think it was suggested then not to listen to my speech during the course of that debate because there was no way in a month of Sundays, I'm not sure that was exactly the terminology, that I was going to be supporting it. And members might feel that today. But the reason I don't support it is quite simply, sir, it does not and will not do what it is being sold to do. It doesn't work. What it says on the packet, i.e. that tenants will pay less, that their security will be enhanced, it doesn't work. And the reason we know it doesn't work is twofold. Well, threefold, sir. And I'll get to the third point, which is really what Deputy Scott was referring to earlier. The first reason we know it doesn't work is because in Jersey, price control has been tried before. And I look across to the connotab of my former parish, and a previous incumbent of his office used to entertain this assembly with the experiences of price control in the housing market and the unintended situations which were ridiculous that arose. The price of the house was controlled. The price of the contents was not. And therefore people paid on the tin a price for the bricks and mortar. But what they did through separate contract was pay tens, 50s, hundreds of thousands of pounds for an article of furniture along with the contract to buy the house. But if you'd asked anybody, either locally or externally, Jersey had house price control, and that maintained house prices in our community. It didn't work. So we do have experience there that shows price control doesn't work. More than that, we have experience from other countries which show that price control in the rental sector doesn't work. Now, it was said during the last debate, and it has been said in public, that this proposal for rent price control is so different from the one found elsewhere that it is going to work. The truth of the matter is that when I look at what is proposed here and what has been undertaken elsewhere, it may be that there are differences, but the fundamentals are the same. In Scotland, where they've had rent control, 50,000 rental homes have been lost. In Ireland, we've seen investment in housing reduce anywhere between billions or hundreds of millions. Elsewhere across Europe, we've seen the same, where rent freezes have cut the number of rental properties available, and in the US as well. So is it the vested interest of landlords that are against this? Or is it the fundamental understanding that despite what is said, this will, it may in the short term, and maybe that's all we're after, it will not in the long term benefit tenants because the supply will be reduced. And that is incredibly important, even though it's been, doubt has been cast upon the importance of supply in the rental sector. And particularly in Jersey, where we have such a high level of need for private sector rental. Of course, there's the political view that that's unnecessary. But whilst we continue to control immigration through both work and housing, we will have a need for a vibrant private sector rental. And it's not actually as vibrant as it was 5 years ago, let alone 10 years ago. if you were making an investment decision into Jersey property, and I'll be careful, some former family members would be turning in their grave to understand what's actually happening in the property market now. It isn't necessarily as lucrative as some others have suggested. If you compare investment in Jersey property with investment now in other parts of Europe or investment in other investments, it's looking decidedly balanced. That's a bad thing for tenants. If we don't have supply, it is supply that leads to choice, that leads to the strengthening of the tenant's position. Because a landlord that's buying a house for investment needs a tenant in that property. The last thing they want is a vacant period, because it undermines the investment even more. It means that they can't reinvest and they can't improve it for the benefit of tenants. So I think we have to be very careful around what we are suggesting is offered, or the benefits that are offered to the public in this regard. The other thing which is interesting about Jersey's private rental sector is there are so many landlords that have either one or two properties. And that's built up over time. And they are what we would describe as average members of our community, who may be through inheritance or maybe through wise saving, are trying to provide for their own family and for their own retirement. That's not the case in other rental markets. In other rental markets, it's highly corporatised. And what we see in rent control and in a highly regulated market is that we will see more corporate landlords. We'll be moving away from those individual landlords. And why is that? I shouldn't be arguing against myself in this regard, but I am, because why is that generally not a good thing for tenants? It's because the smaller landlord that's got an interest in their own family and got an interest in their own retirement is able to maintain rents, is able to extend tenancies, is able to be really very flexible and understanding in order to maintain their tenant. That's not always the case with corporate landlords. So that, again, would be a bad thing. And I know people will say, well, landlords don't have to increase their rents by RPI. The Minister has very wisely said that he will accept an amendment which removes the 5% cap. And I think that is a wise thing to do. Landlords won't need to put their rents up every year. They won't need to put their rents up by RPI. But let's be clear about the forces that will encourage them to do that. And those forces are that in the future, let's say one has had a tenant for 5 years, one has, for all sorts of reasons, not increased the rent, and then there is a problem with drainage. Landlord then has to invest tens of thousands or tens of thousands of pounds to sort that drainage problem out. If the landlord hasn't been increasing the rent by RPI every year, as allowed to under this, it won't be possible for them to suddenly come along and say, the Minister is shaking his head and saying that I am wrong. Of course, in theory, I am wrong. In theory, I am wrong. But we're not talking about theory. We're talking about real-world economics. The landlord will have to go to the rent tribunal. The rent tribunal will make a decision outside of the control of the landlord. and it will be very difficult to argue the case because repairs and improvements are substantial investments. So I think that is a reason why landlords will be pushed towards the RPI becoming the floor and the norm every year, and that certainly isn't the case now when we look at the trend in rents. I said there were threefold reasons, and the thirdfold reason is economics. There is a cost to landlords in the changes to this legislation. Economic assessment was undertaken. I'm not quite sure why that wasn't given to members or scrutiny. But we find ourselves in a situation where actually a better economic assessment, in my mind, would have been able to be undertaken had we actually gone out and consulted both landlords and tenants and gathered data about length of tenancies, about current rents, about trends in rents, and all of that information to be able to make informed choices. So I actually think the economic assessment would tell us that there will be unintended economic consequences, but we're being asked to make a decision without fully understanding what they are. So I would also say that a number of members are probably going to support the principles today because the scrutiny report suggests principles should be supported, then we can consider the details of the articles. But I would just caution those members who think that that is the approach that should be taken, and not to be surprised if it is suggested as we get to those amendments that they actually don't work in practice in their interaction with other parts of the law. So members might be thinking they're going to be able to accept various amendments and they'll be able to treat and get to a point in the legislation that they're satisfied with. I would just warn them that I'm not sure it's going to be that straightforward. And so it is therefore, I recognise that there are some benefits to this legislation, but I fundamentally don't think that rent control is going to work, and I fundamentally think that there are going to be other unintended economic consequences to this legislation. And that's why, sir, I will be voting against the principles. Thank you.
Thank you, Deputy. Does any other member speak on the principles of this amending law? Yes. Deputy Secretary.
Thank you, sir. I'll keep it very brief, but given that it's a rare occasion I get to speak after my old friend Deputy Gorst, I thought I would take the opportunity simply to say that I think the tone of this debate has been, I think, more welcome, and I think largely because of the interventions from scrutiny. I think we had a very clear, of course, maintaining of the principles by the Minister, but we had a very good speech, I think, from Deputy Jeune, speaking on behalf of her panel. I think they need to be congratulated for having done a sterling piece of work in fairly short order, which was, of course, referred to them during the first reading. We haven't got to the first reading, of course, we're still doing it. The first thing to say is that it would be very strange if this Assembly were to have referred something to scrutiny and then reject the principles because they don't want to hear what scrutiny's got to say, and to at least consider the amendments that they've put forward, most of which I understand are being accepted by the Minister, and certainly that seems to be where the real value will be added to the debate. And I also actually agree with something Deputy Balash said, but it's been echoed, that ultimately what this is about, this debate, is about striking the right balance between tenants and landlords. Tenants and landlords are the most happy when they're in a relationship where they both have clarity about what the expectations are, where they presumably can hope for security of tenure, and where possible have as long a tenure as possible because the landlord has a guarantee of income and that family has a guarantee of its home as long as they want it. And of course we know that can never be complete parity in the power structures. Of course, tenants ultimately have to decide when they want to move on, if their situations change. And of course, we also know that there are many legitimate reasons why a landlord would want to bring a certain tenure to an end. And I think that is all captured. And these are the details that we should be looking forward to getting into when we debate the second reading of the legislation. Therefore, I hope that the media won't be proved correct when they say that there was a wrecking amendment to refer this to scrutiny, because actually this Assembly should be saying, no, we referred it to scrutiny to get some extra value. There were debates, of course, about at which point it should have been referred. Should it have been done in the first or second reading? But it's been done now, and I think we all need to listen to that. We do, of course, hear the old chestnuts from my friend Deputy Gorst. One of the key ones is that landlords will sell up and there will be a reduction in the rental housing stock. And I've asked it before, perhaps the Minister can also comment on what his analysis has been. But presumably these properties, in the doomsday scenario, they don't just evaporate, do they? What happens to a rental property that a landlord, for a landlord who no longer wishes to be a landlord? They must sell that property, presumably, because they're not going to sit on an empty property. We've heard that it's not in anyone's interest to keep a property vacant. So you sell that property, don't you? You sell that home, as Deputy Ward would say, and you either sell it to somebody who is currently a tenant who wants to become a homeowner, and they buy that home and they live in it. So you've got one less tenant, you've got one less home. So it is a zero-sum game. Or the landlord, the outgoing landlord, sends it to another landlord who wants to become a landlord, and therefore you have another rental property, and so there's no change there. It's a zero-sum game. I would like to, if I'm wrong on that, I'd like to hear from members, but that seems to me the way it should work. And of course, there's this idea that there are also corporate landlords out there. There are, of course, entities like housing trusts and Andium. So as somebody who has declared an interest, my wife is a landlord, unintentional if you like, but it's somebody who owns one property, who seeks to be as ethical as possible, who presumably seeks to keep that maybe until her retirement or beyond, who knows. But there are lots of people in that situation, and she wouldn't mind me saying she doesn't have a problem with what's being proposed here, and that there are lots of landlords in Jersey who don't necessarily feel that the JLA speaks for them. And there'll be lots of landlords, of course, who are members of the JLA, who I suppose have different points of view. And there are lots of tenants, of course, who I think have had different experiences. So this isn't just one homogenous debate where we can pit one side against the other. And I think actually I really want to hear some of those nuanced arguments, those amendments that are being put forward in the second reading, so that we can get to a point. Because ultimately, housing is a recurring issue. It comes up at every election. And I think we would be doing ourselves a disservice only a few months away from the beginning of an election period, where we know that we've been told that almost half of islanders may be in a position where they're tenants. Of course, half of the island are not landlords. I think that goes without saying. And we need to have that balanced debate about where the just legislation needs to come in. And that's what I'm really interested in getting to. So let's please support the principles. If members really want to see a different type of legislation, they will certainly consider voting for the amendments. I, for one, will be really looking forward to what's being put forward by the scrutiny panel. But certainly, I think we can get to a point at the end of tomorrow, I hope, or before the end of tomorrow, where we have something in front of us which is both workable, which is helpful for tenants and landlords, and which certainly gives those many thousands of families in Jersey who are in a position of renting to know that their position has been ameliorated without necessarily, of course, having to do anything negative towards good landlords who are already operating following good and best practice.
Thank you, Deputy. Conor St. Peter.
Thank you, sir. There is little doubt that there are a minority of both bad tenants and bad landlords, and I would fully support legislation that targets these two groups, particularly those landlords who discriminate against families with children. However, the vast majority of both tenants and landlords are considerate. The vast majority of landlords maintain properties in good order, do not impose undue financial demands on their tenants and treat them with respect. Likewise, the majority of tenants respect their properties, which we must not forget are their homes, and have good a relationship with their landlords. I found it difficult to support this legislation or the principles that apply a blanket approach to this issue and impose burdens on good landlords, in particular when only a minority exploit the current legislation and do not respect their tenants. I am, however, pleased that the Housing Minister has accepted the amendment to remove the proposed 5% rent cap, and landlords can now plan for expenses like mortgage payments, maintenance and cost of living. A good landlord will always consider the impact on their tenants and consider them when an increase may be necessary to cover additional maintenance or improvements. Prior to the Minister accepting that change, I had looked at the impact of rent caps and rent controls in other jurisdictions, and therefore my speech is significantly shorter than I had intended. However, one thing that connected all the jurisdictions I looked at, the US, Germany, and Scotland, was that rent controls had resulted in landlords selling off stock, and that tenants, post these changes, had in fact experienced higher rents. In 2017, Scotland brought fixed-term tenancies to an end as proposed by this legislation. It did in fact result in significant numbers of landlords leaving the industry. Many were good landlords who, prior to the legislation, will have had a good relationship with their tenants. The result was less choice for tenants and an overall increase in the rental values being applied, which is detrimental to the tenants involved. My concern is that landlords who have tenants on fixed-term contracts, where both parties are happy with the arrangements, will walk away, as they do not wish to be faced with the difficulty of regaining their property in an emergency. The amendments by scrutiny, and I commend them for the important work they have done, goes some way to dealing with this. But a landlord who might be facing a life-changing event may not have 12 months to wait. Some of our landlords, particularly the majority who are single landlords in Jersey, are elderly and more likely to face these problems. These landlords need the income guarantee that comes with a fixed tenancy, and the tenants also have certainty that with a fixed tenancy, the landlord cannot serve notice of eviction. We have been asked to provide evidence to back up the content of our speeches, but I have yet to see evidence to back up the claims in respect of revenge evictions. There do not appear to be significant numbers, so how can that be used to justify some of the proposed changes? I will continue to listen to the debate and for the summing up by the Housing Minister. One of my main concerns has been resolved, and scrutiny have made efforts to remove some of the downside of open-ended tenancies, but I would have preferred to see a shorter notice period than 12 months where a landlord finds themselves in difficulties. Whilst the legislation is well-intentioned, there is little doubt that there are negative unintended consequences which will have an impact on both landlords and tenants. These include reduced housing supply, and as I say, that is backed up by the experience of other jurisdictions who have passed similar legislation. This proposal, if approved, is likely to see landlords continuing to sell stock. I spoke with an estate agent I've known for 50 years. He has landlords offering him properties and asking him to put them on the market. There are not other landlords coming into the market to take those up, unsurprisingly. And therefore it is likely that this will certainly see a fall in the number of properties available for rental in the short term. This in turn will deter new development at a time when Jersey's construction industry is in crisis. In the current climate, I have significant concerns about the deterrent to the future construction. In the last few years, 9 construction firms have ceased trading. I have little doubt that this legislation will be a further blow to that industry and the subcontractors and businesses who rely on it. What will happen to the families and children of these subcontractors and workers and the associated businesses in which they work, who rely on earning an income from that industry? We may well witness further closures as a result. I would welcome legislation, as I've said, that only targets the minority of individuals and businesses that are bad landlords and tenants. But I have difficulty in supporting the proposals in their current form. Thank you, sir.
So would the Constable give way for a point of clarification? I promise it's a sincere one, not trying to score a point. And thank you to the Constable. So he referred to the proposal that's found in the scrutiny panel's amendment for the 12-month notice system, and he spoke about his concerns about landlords facing life-changing events where 12 months might be too much. In order to help me with my summing up, would the Constable mind just kind of elaborating on what kind of life-changing events he was thinking of when he said that?
I think what I'm hinting at, which is obviously something that I've gone through with my wife, is somebody who is aware that they have less than 12 months to live, and that if that's something that I would perhaps like to see covered.
Thank you, Conor. Does any other member wish to speak on the principles? Accordingly, I invite the Minister to reply. Minister.
Thank you, sir, and thank you to all members who've taken part in this debate. I set in my opening speech some challenges to those members who were going to be critical of this law and seek to oppose it. And so naturally a large amount of my summing up is going to dwell on what I think the response to that was. And of course, I have to start with that from Deputy Gorst, who served us up a banquet of red herrings in his speech on this, sir. And I make this point very seriously, that it was noticeable that when he spoke against this law and this proposition, that in almost all of his speech, he did not actually address any of the tangible proposals that are in this draft law. And when he finally got round to doing so towards the end, he got his facts wrong about what the law actually contains. So he served us red herrings by talking about the rent control systems in Scotland and Ireland, and about the former house price control system in Jersey. All 3 of those things are, of course, nowhere to be found in this draft legislation. And I can tell members that the Scottish example was one we specifically looked at as a model of what not to do. And the model that they have there and the model that they have in the Republic of Ireland are, in their detail, absolutely nothing like what we have proposed in Jersey, sir. And it is very clear why those members who cited those examples didn't seek to get into the detail, because if they were to have done so, it would have shown that the point they were making was either totally invalid or that they hadn't familiarised themselves with the detail of the rent stabilisation metric that's proposed in this draft law. So let's be clear about that. So in the Scottish system, rent increases are capped at either 3% or, with permission from the state, they can go up to 6% if they think they've got a reason for it. The Irish system is not too different, except the only ability to realign rents comes at the point of a new tenancy, and it's focused on rent pressure zones, which is obviously completely irrelevant to this law, sir. What's proposed in this law is, of course, nothing like that. It is an entirely passive system where, in almost all occasions, nothing will happen as a result of it. It simply has a backstop position put in for if a particularly unjust circumstance arises. So, under this law, ordinarily, if a proposal is made by a landlord to increase their rent, It will be exactly the same system that it is now. They write to the tenant to say, I've conducted the rent review and here's the result of that. And the tenant, if it's beneath RPI, they have no choice whatsoever. That's the rent review and that's that. If it's above RPI, they would have the option to appeal it to an independent rent tribunal, and that tribunal will be independent, and it will have the power that if that inflationary rent increase is proposed with no justification, that they would have the power to overturn it. But if it is justified because the landlord hasn't raised rent for several years and decides that now's time for a catch-up, or the landlord's investing in the property, and then that duly and reasonably means that more rent ought to be considered due as a result of that, the tribunal sides with the landlord. And knowing that in those instances where, if you've had it good for a few years without a rent increase, the tribunal's not going to side with you if you attempt to appeal it to them. So that regime is entirely passive. It requires nobody to ask for any permission for anything. It is absolutely unrecognisable compared to the two jurisdictions that have been cited on this. So Deputy Ayer referred to the history of a tribunal. He said the tribunal failed before and it will fail again. This is particularly amusing, sir, because it is possible through Statistics Jersey to go back and look at their rent index, and you can see, sir, that in the final years of the old rent tribunal, rents were going up at around about inflation. And guess what? When that tribunal disappeared, they spiked at that point. And then when the 2011 residential tenancy law came into force, they spiked again and started going up by even more than inflation. So I'm not saying that's absolutely hardcore definite evidence, but it is interesting that the last time we had a rent tribunal, rents were bubbling along at around about inflation. Sir, in my opening speech, I did attempt to set some traps for members who may come forward to oppose this law. I was very deliberate in doing so, and I didn't anticipate just how quickly a member would fall into every single one of those. I'll try to be dispassionate when I go through the remarks that were made by the first speaker in this debate, Deputy Barbara Ward, sir, because she did, I think, make some very clear mischaracterisations of the law and of the current situation, sir. I had made a specific challenge to members to point out if they wanted to claim that there was red tape or bureaucracy, they should be very specific about that rather than just use it as a convenient term to disparage the law. And Deputy Barbara Ward attempted to do so and, of course, got it completely wrong. She said that there would be bureaucracy involved because evidence would be needed if raising rents. That, sir, is not true, because in the first instance, a landlord proposes their rent increase through the form of their rent review to their tenant, and there is no requirement at all for them to produce any evidence at that point. The only point that they would be required to produce evidence is if a tenant looked at it, said, this is clearly out of order and not compliant with the law, I don't think it's justified, so I'm taking it to the rent tribunal. At that point, a landlord would have to come up with the evidence at that point. But if the landlord had that evidence and a tenant indicated that they were likely to appeal it to a rent tribunal, the landlord would show it to the tenant, and the tenant would realise that they have no case at that point and they're destined to lose when they go to the tribunal. So that would end up avoiding that entire circumstance entirely, and it would only come into it if people were being really persistent and refusing to budge when there was genuine doubt that they were compliant with the law at that point. Deputy Barbara Ward also, she referred to the economic percentage that rent counts as part of our economy. It wasn't 100% clear what percentage she was talking about, but she cited the figure 11%. If she's citing the one that I think she was, she'll be interested to know that that figure is not actually all real rent. It's also deemed rent as to what the value from homeowners ownership in a home would be. So it's actually, as a statistic, it's actually not indicating what the deputy thought that it indicates. But most seriously, and I think Deputy Balash did this as well, is there has been a very clear attempt to undermine the dialogue on revenge evictions by making constant reference to the Petty Debts Court process as if that has anything to do with it. And it's really disappointing that some members persist in doing that, because that has been debunked on the floor of this Assembly multiple times. So the Petty Debts Court will not have any records at all of revenge evictions for the simple fact that there is no requirement to register revenge evictions with the Petty Debts Court, because a revenge eviction is not a legal term. It is an informal term that's used to describe a situation where a landlord issues notice to their tenant in retaliation or revenge for the tenant attempting to do something that would otherwise be considered reasonable or to uphold their rights. It's not a description of the process of going through court. And of course, if a tenant receives notice given to them as retaliation or revenge, most of the time, that tenant's not going to challenge it. They're just going to begrudgingly comply with it, because they know that the Petty Debts Court will not side with them in seeking to have it overturned. And that's the key flaw with our 2011 residential tenancy law that I think other members, Deputy Scott, I think, came across as, and has done in some of her amendments, as not understanding this point either, that the Petty Debts Court, it cannot overturn a notice that has been issued lawfully. The only thing it can do is grant a stay of eviction, but that stay of eviction is not granted on the basis that the notice was issued unjustly. It's issued on the basis of the harm that would be done to the tenant in enforcing an eviction in the short term. Remember, sir, that if you're living under a stay of eviction, you technically meet the definition of homelessness. You have no housing insecurity, housing security in that position. You don't know when that stay might be over, and there's no guarantee, of course, that it would be permanent. And as I said, it's granted on the basis of the vulnerability of the tenant. So you can be a tenant who's actually not particularly vulnerable. You've just been subjected to some really bad and unjustifiable behaviour. But if you have the capability to move elsewhere, tough luck, you're going to have to, even though you've done nothing wrong. So, sir, that is the fundamental flaw of Article 6 of our current residential tenancy law, that a power does exist that, if used, will end with a tenant losing their home, whether it's at the end of that notice or at the end of a stay of eviction, and they have no right to challenge it and have that notice overturned. And the fact that they don't have that right obviously means that many don't bother challenging it, because the only thing that they would be able to buy through going through the Petty Debts Court would be some time, and it would mean having their name published in a record that future landlords may see it on and go, oh, this person's a troublemaker, I'm not going anywhere near them. That is no good right. That is not something that's going to be something that helps tenants to be able to secure themselves. And that, sir, is why when Deputy Balash says that part of the solution here actually is to make greater efforts to educate people on what their rights and obligations are, his proposal is flawed, because if we're to do such an exercise on an honest basis, it must involve telling tenants where the holes in their rights are and where the limits of what they can do to protect themselves are, and to tell them the fact that even if they do something totally legitimate, like complain because the mould isn't being dealt with properly, that at the end of the process that they undertake to defend themselves, they will still lose their home, and the institutions of the state will force that to happen. That, sir, is to tell a tenant that their rights are not particularly strong, and the obvious effect of that will be to affect their behaviour in not standing up for themselves when they otherwise ought to, because they are the ones in a righteous position there. But so I would say it is already the case, sir, that there is lots of information out there about this. There is a government web page that has rights for landlords, rights for tenants, that's put out very clearly. And there are organisations in our society that can do very well to help people understand what those rights are, including Citizens Advice, which is completely free of charge. And, sir, Citizens Advice, of course, have fed into this process, telling us that they get people coming through their doors telling them that they're subjected to these behaviours. So we can't just download a spreadsheet that has all the data for every revenge eviction because they're not registered, but we get feedback from those at the coalface telling us that this does happen, and they're not lying. They're telling the truth. These cases exist. They do happen. And that is why, in proposing this amendment law, a regime has been put together that is so light touch and passive that I think it does meet the aspiration that the Constable of St Peter was talking about in his speech, where he said he wanted to support legislation that only targets the bad landlords and tenants, and the phrase sledgehammer to crack a nut was used by another member as well. So the impositions that this draft law put on landlords are in many cases non-existent. That's why I put that challenge out to members to say, if you're talking about red tape, or you're talking about bureaucracy, be specific about what it is, because it is the fact that this law proposes no new forms, no new fees, and no new permissions. In the first instance, everything carries on exactly as it is, as long as, when you're drafting your contracts, you make sure that those contracts are in line with the laws of the island of Jersey, and that's what most contracts actually have most contracts I've seen anyway, normally have a line in it that says that that's their intention in there. Then you don't have any interference, you don't have extra costs, you don't have extra permissions to ask for. So there's no disruption, there's no forcing people to engage in compliance or behaviour that really is any kind of imposition against them. And when it comes to the legitimate circumstances where landlords will want to safeguard their assets or want to manage their portfolios properly, I have not heard a single member say why this law would get in the way of them doing that. Many have claimed that it makes it harder and also more difficult, but when challenged on the detail, that was the specific challenge I made in my opening speech, none have been able to point to something that would actually get in the way. So the biggest difference, if you want to call it that landlords might have when issuing notice to tenants to get their properties back, is that they might just want to put an extra sentence in that notice saying what their grounds are. I don't actually think in the law it's a requirement for them to do that, but they would be well advised to do it so the tenant knows in advance and knows whether it's challengeable or objectionable. But if, sir, a landlord is selling a property, they would want to just put that in the notice to say, I'm hereby issuing you your 3 months or your 6 months, and here's the reason why. Let me know if you've got any questions or want to talk about it at all. That would be the first thing to do. But so the framework proposed with shorter notice periods for certain grounds is of benefit to landlords. If a landlord is worried that their tenant is causing damage to the property or they're behaving in such a way that is really putting at risk that asset, they will be able to issue notice that comes at a much shorter period, which means if there's a problem and the tenant's not playing ball and refusing to leave, they can get to the Petty Debts Court quicker than they otherwise would have been able to. Now, can somebody tell me why that's not an advantageous thing for a landlord to have in those legitimate circumstances? That's something that they wouldn't be allowed to use for illegitimate circumstances, quite rightly. But for those circumstances where few of us would disagree that it's right and necessary, they will have that ability that they don't currently have. And that, sir, is why the law is balanced, sir. Why the only negative elements of it, those restrictions and prohibitions, are tightly targeted specifically on the behaviours that I presume none of us would justify. Nobody in this room presumably would justify a landlord wanting to issue notice because the tenants complained one too many times about why they haven't had their deposit protection certificate, or why they haven't had somebody round to check that leak that's causing a problem. Nobody would justify that, and this law prevents that from happening. But equally, nobody would say a landlord shouldn't have the ability to get back their property when the tenant is in the wrong, and this law makes that easier. That's where the balance comes from there. Deputy Reniff used a phrase that I quite liked. He said that there were plenty of problems if you have your eyes open to see them. And it sounds to me, sir, that many of those in opposition to this law are very keen to disregard the real-life experiences that we have had explained to us, either in direct testimonies, those that I've shared, or in the survey results that Scrutiny had. You know, they themselves did their exercise on this and heard plenty from that. And no, sir, I can't tell you whether it happens a dozen times a year, 50 times a year, 200 times a year. I can't do that because by design we don't have procedures in place, requirements in place for any of that. But we can tell from the detail of the propositions in this law that if the measures in it are adopted, we can curtail much of that. That cancer patient I referred to, who has been told by her landlord that if she keeps complaining about the mould, she will issue notice against her rather than just do her legal duty now and fix it, she will be protected because that notice will be invalid, and the Petty Debts Court, if it ever got there, would not uphold it because for the first time they would have the legal right not to uphold it. That case is resolved by this law, and many others with grave similarities to that as well that are resolved by it. But that landlord who has a troublesome tenant that is really causing them difficulties has a quicker route now to getting back that property. And that situation, like what the Constable of St Peter talked about, I specifically asked him about those life-changing events who might not have 12 months. Well, in any event, they would have the 12-month notice. They don't have to justify that or provide grounds for it. So that's something, and that's better than the original draft law there. But if they decide that there's something more urgent they need to do in the meantime, that they'd require quicker notice for, I would kind of want to know what that is, what their life-changing circumstance, what is it they'd want to do with that property? Is it that they'd want to sell it? Because if they want to sell it, laws already covers that. They've got a notice period for that. If it's they want a carer to move into it because they live close to it and they want that carer to have quick access to their ill relative, that's covered in the law as well. That's allowed for that, and there's a shorter notice period than 12 months for that. So these things are covered in that, and I genuinely struggle to think of ones that aren't covered by it, and nobody in the Assembly who's opposing the law has attempted to do so either. So I don't want to dwell too much on the comments from Deputy Scott. She did make a phrase that she admitted that she knew I'd take exception to, which is that the law in some senses will turn private rentals into a form of social housing. I hope we can disregard that because that's obviously nonsense and obviously not what will happen. But if I could take exception to a specific comment made by Deputy Wilson about my change in position to accept Deputy Reniff's amendment to scrap the 5% part of the rent stabilisation cap, which she described as lawmaking on the hoof. And I'm pleased to be able to evidence why that's not the case. Because when we started this journey in putting this law together and putting some kind of rent stabilisation metric together, I was open-minded about what the cap would be. I had in my mind what I thought might end up being my preference, but we looked at the market, we took advice, we ranked different proposals on key indicators, and it just so happens that the RPI plus 5% cap was the one that ranked highest. It wasn't the one that I thought would rank highest at the start of the process, so I had my mind changed by that. But so we did examine having just RPI, and that one ranked very highly as well. So this was one that was on the table for a very significant period of this work. So it's not on the hoof. It's not something that wasn't tested along with the original proposal. It was tested in that process. It ranked highly, and I'm absolutely confident, and would have been confident if that had been my first choice anyway, that it is a far better system than what currently is in place, where there's no ability for a tenant to appeal on anything at all. So I was really pleased that Deputy Doublé referred to the Life on the Rock report from the Children's Commissioner. Isn't it very telling that a survey of children, people who themselves are not directly responsible for managing the homes that they live in, because that's their parent or guardian's responsibility, those issues have permeated down into the consciousness of children in the island, who themselves are telling us when they're asked how much of a serious issue this is for them and their families. And this draft law, which has its children's rights impact assessment, I'd be interested to know how much attention has been paid to that, I think seeks to provide better security and stability for children who aren't having to be moved about to different homes on the whims of landlords who haven't provided decent justification for why they want to end their tenancies, and for their parents to not have to stress out about all of that all the time because they know they're in a home that's decent, safe, secure, and affordable, or have affordability predictable into the future because of it. And that's something that the current law doesn't offer us. So when you look at international comparators, what's proposed here is not radical in any shape or form. The system in the 2011 Residential Tenancy Law is very similar to that in the 1988 Housing Act in the UK. That act is about to be abolished and replaced with a new law very soon, because they believed that that experiment of having fixed-term traps and insecure periodic tenancies doesn't work. It's much better to have more flexible fixed terms and periodic tenancies with safeguards in them. That's better for both landlords and tenants. That's the direction that they're going. And Jersey not following there will make Jersey a less attractive place to live. And it will, I believe, if the Assembly rejects this draft law, send a message out to people in Jersey, particularly young people in Jersey, people in perhaps their early 20s coming out of full-time education, but also to their families and their parents, that there just isn't political interest in trying to make renting a bit more of a pleasant and predictable experience for those who do it, for them in their early working lives to then plan for their future, save up for a deposit or anything that goes with that, that we're happy for a free-for-all where that security isn't built into it, and where the offer that we give those people is substantially worse than that they would find elsewhere. It has already been the case for a very long time that home ownership offer in Jersey has been more unaffordable than other places. To have that as part of the landscape, as well as an unaffordable and insecure rental offer, is, I think, a recipe for disaster that will give more young people in Jersey a lack of confidence that they will have a prosperous future in Jersey. So, as members can tell, I'm running out of steam. It's been a long and good debate, and I hope members will accept the principles of this law. There are still things to be done in the debates on the amendments, and I've taken positions on the scrutiny amendments, which is generally in favour. Not in favour 100% though, but even the ones that I'm not in favour of, if they are adopted, I certainly don't regard that as the end of the world and still regard it as progress. So there won't be any issues from me if the Assembly disagrees with me on those sides of the amendments. But generally what that's seeking to do is to improve a law, and I hope that the Assembly will get the opportunity to debate those. So I call for the appel.
That has been called for. Members are invited to return to their seats. I invite the greffier to open the voting. All members have had the opportunity of casting their votes. I ask the greffier to close the voting. I can announce that the principles have been adopted, 29 votes for, 19 votes contra.
I propose the adjournment, sir.
Could we ask for the votes?
The names, please, sir.
The names first, please, greffier.
Those members voting for the Conotaba, St Helier, St Lawrence, St Peter, St Martin, St John, St Mary and St Saviour, and Deputy Southern, Tadier, Doublé, Rob Ward, Alves, Gardner, Farnham, Moore, Mezek, Corey, War, Miles, Renouf, Catherine Curtis, Feltham, Jearn, Miller, Kovac, Alex Curtis, Stevenson, Andrews and Coles. And those members voting contre, the Conotaba, St Brelard, Trinity, St Clement, Grouville and St Juan, and Deputies Labby, Luce, Morel, Lahegara, Ayer, Gorst, Balash, Scott, Rose Binet, Howell, Tom Binet, Ferry, Barbara Ward and Wilson.
Members content to adjourn? Assembly is adjourned until 9:30 tomorrow morning.
Is it me?